Yes, sister, good morning.
Good morning, sir.
In the conspectus of the aforesaid discussion and the materials on record, we are of the view that the conclusion arrived at by the learned session just so and so does not warrant any interference. Appeal stands dismissed. Yes.
I'd like to mention a listing for a IA criminal for 13th of May this month. I'm led by the outstation counsel. Earlier, I have mentioned for the listing.
IA criminal
IA
for
criminal.
suspension of sentence.
For modification of the order, dispose order, it was disposed. Actually,
In a criminal appeal.
criminal appeal. Sorry, Lordship, WPC criminal. WP criminal, petition criminal.
Okay, what was the nature of the order?
Actually, in that order, the custody of the girl was given to the father, and mother was allowed to meet her in this twice in a week for through telephone, and from 7 p.m.
But dispose of matter will an IA lie.
Actually, now Lordship, she was admitted to a boarding school. So there are some.
Understood, but if the matter is disposed of, will an IA lie? We are not in season of the matter. The matter is
Disposed of.
over.
Over.
Only on very peculiar and very limited scope. And I might lie. We are not saying that it's not possible at all. There are case laws. But Brahmabhat, I think, Brahmabhat says that dispose of matter, I normally will not lie. Brahmadat. We are not very sure. If you are seeking something else, then you have to file an appeal or not very. Who is your senior?
I am particularly led by outstation counsel A. Fupon. In here, I am my senior.
He could have appeared online.
So he will come on 13th of this month. Some other matter is.
Okay, we can, but we are expressing our doubts whether an IA will lie in a disposed of matter.
Lord.
You make some research. There are case laws,
Lord.
Peculiar circumstances, limited circumstances. I might lie, but we do not know what is your case.
Lord.
You cannot open up a new cause of action.
Lord.
You can try.
Deeply.
I'd like to mention item number 5. The engaged from the Jadal type. Engaged counsel Mr. Jadal type.
Okay, you inform the other side.
Yes, sir, I
On a request made on behalf of the appellant, matter is adjourned by 2 weeks. Ms. Jahan, learned APP is present. Yes.
May I please, Sir Lordship? I beg to mention for item number 2, Lordship.
Yes.
Learned America Security inform me over telephone that is unaware, Lordship.
You
Kindly
inform,
matter may be fixed after 1 week.
have you informed the other side?
Okay.
There is a
I
legal
already
aid
informed the
counsel.
other side.
Huh?
I informed the other side.
Legal aid counsel already informed.
Informed.
Okay. It is submitted that Rian Hassan, learned America Security, is having some personal difficulties and therefore could not attend the court. Accordingly, adjournment is sought for. Para? List after a week, 1 week.
Bless Lord.
Yes.
please, sir, I'd like to mention item number 10 of today's staying for adjournment due to some personal difficulties for my senior engaged counsel on behalf of GI board.
Madam Borwa, Gohai Borwa. Item 10.
I was not informed. Oh,
You should inform first. You expect her to be in the court while mentioning. Why don't you inform first? What is this kind of practice? You're not new to the bar.
actually, lot of
You should inform first, then make a mention. That is not the practice. On a request made on behalf of Sri G.I. Borbhai, learned counsel for the appellant, matter is adjourned by 1 week.
published.
Ms. Jahan, learned APP, and Miss G. Borua, learned amicus curiae for the respondent 2 are present.
Obliged.
May please, Lordship. Lordship, I want to mention regarding listing of a MAT appeal, Lordship, for hearing on next Thursday.
Case
It
of
was
which
last
year?
of 23, Lordship.
Was it listed for hearing earlier?
No, Lordship, it
Then
was
how will
for
it come for hearing in a mention memo? People, how many depositions? How many witnesses?
3 as far as I could remember.
Have you made copies of the deposition?
Yes.
You're not even certain. You're mentioning for a hearing.
In the last occasion, actually, Lordship, we
Have it for orders in the next week. We'll see
Okay,
the
Lord.
records
Okay.
and make copies of the deposition for your convenience, not only the convenience of the court. Okay?
Okay.
For orders, make it for orders.
Okay, Lord.
Other side served.
Yes.
Others, who's appearing?
B. Acharya and A. Acharya. In the last occasion, they were given instructions to bring, the matter was heard. So that is why no date was fixed, Lordship. In the month of December, it was taken up the last
December what?
24,
2024?
20.
Okay, next Thursday.
Sir,
Yes.
regarding item number 9, my lord,
Hmm.
just come up for hearing, my lord. They are not feeling well. The only issue is, my lord, it is tagged with item 8, but they are from different appeals, my lord. My case is a POCTO case, my lord, and item number 8 is a murder case, my lord.
Not connected.
Not connected. It was tagged because, my lord, there was one common issue of law involved in both cases. The effect of the absence of a public prosecutor during trial, my lord. So on that ground, these two cases got tagged, my lord. Otherwise, mine is a POCTO case, that is a murder
Who is
case.
appearing in 8?
8, my lord, Mr. A. Ahmed is appearing, my lord. They will intend to go for the hearing, my lord. But I was not feeling that. It may be segregated, my lord. Come up.
But if they argue on the aspect of lack of absence of the public prosecutor,
Right.
your input may also be necessary. If you take a decision, it will affect you. If you are taking a decision against you, then we'll not rehear the matter.
Right.
Only because it's a different case. If the tagging was done consciously on this point of law, you'd like both the point of law to be examined.
In that case, my lord,
Tomorrow, you might say that I had this point which I could not, which was not brought to the notice.
in that case,
Can you wait for next week?
no, my lord, in that case, let it be there because they are in jail, my lord. So I don't intend them to be prejudiced, my lord.
No, that is okay. No, can you wait till the next week? Huh? We will give a date next Wednesday. He's not feeling well. Next Wednesday, okay? Your S Nawaz.
Yes, my lord.
3S Nawaz learned counsel for the appellant in criminal appeal so and so, 252. Submits for little, prays for a little accommodation as he's not feeling well. Criminal appeal 174 of 2023 is connected as there is a common point of law involved. No, though the impugned judgments are different, are entirely different since there is a common point of law involved. Criminal appeal 174 of 2023 is tagged. The learned counsel in the said appeal has expressed urgency. Also heard Ms. Jahan learned APP, LDB
I have informed, my lord.
and LDB learned, also an LDB learned legal aid counsel for the respondent number 2 in criminal appeal 252 of 2022. In view of the above and in the interest of justice, the appeals are adjourned to be listed on
14th,
14th. Okay, 14th.
deeply obliged. You may please your lords. Now, in this case, my lord, the
Just give us 2 minutes.
Yes.
Madam, we have recorded your name in one of the case as legal aid. Ten witnesses.
10 witnesses. One is MO and IO is there. 9 is the MO, 10 is the my lord IO.
Conviction under
302 and 201.
the appellant is a lady.
Lady means and mother of the it's 1.5 year old.
Murder.
Yes, that is my lord crux of the my lord matter. Because this matter is it's not that there is no eyewitness. It is
What is
circumstantial
it called?
evidence.
Filicide or what? Filicide. Filicide.
That none of the witnesses has seen this incident. The circumstantial evidence is that everybody's case is that she confessed before the villager. All the witnesses and villager. That is the case. Now, witness number 2.
What about 313?
313, my lord, she confessed. She killed her son. But she also said, I don't know why I killed my
84 plea taken.
84 plea was not taken defense. But the thing is that, my lord, as per section 329 of the CRPC, my lord, if it appears to the court, my lord, then court has to examine, my lord.
But no, 329 will come into play when the trial is going on. What about the aspect that at the time of commission of the offense, that is the crux of the matter?
Yes, that is there, my lord. Defense was not taken.
That defense is a
That
general
defense was
exception.
not taken. My
General exception will not come just like that. Everybody will say that I was insane.
lord,
Matter will end there.
three things, sir, my lord, just come to my mind. One mother cannot kill her son without any, my lord, anything in their mind or any imbalance.
That you need to take as a defense.
Yes.
That I did not know the consequence of my act. That it was either wrong or
Defense
contrary to law.
defense was, my lord, it's not taken very.
This side case, this
Huh?
is 1.5. They had poured hot water and also because so rare. But then those confessions are before police. Police was there.
But 313.
Police was not there.
But then the
It was
informant
before the
said,
villagers. No,
informant said,
informant is before the no, police say, I also say before the villagers.
But what about 24? Was there any threat, inducement, promise?
My lord,
Beating,
inducement,
injuries?
my lord, one part, man, I have come from this PW8. Your lordship may kindly see PW8 evidence
Now,
at
wait,
page
let-
19.
let us go serially.
Yes, your lord. My lord, PW1, my lord, that informant,
First, Ejahar.
Azhar, your lord. Azhar, your lordship at page 4, my lord. It starts with page 1, but relevant portion is page 4. Married.
31-3.
Yes, sir. That is one of the aspect, my lord. 31-3 at 5:30, my lord. 7. He searched for the my lord the son. Did whole night. The son was not, my lord, found.
He is the husband.
Husband, my
Pension Surin. Pension is in PW1.
pension Surin at PW1.
Informant.
Informant, your lord.
Yes.
Now, your lordship may kindly see page 8, that's deposition of PW1.
No, you read the Ajahar first.
Yes, as I am just at page 4, your lordship.
Mr. Chaudhary, which matter is yours? Mr. H.R.A. Chaudhary. Which matter? This will take time, at least 1 hour. You come after 1 hour. 11 is what? Hearing matter. This will take at least 1 hour. I have some junior of yours by around 11:30.
Yeah, any matter.
No, 11:30, ask them to come and because it will take at least 45 minutes, 1 hour.
My lord, may I read? Sir, humble submission is that around 7 p.m. yesterday, I came home after playing volleyball and asked my wife, Srimati Luthia Surin, about our son, Powell Surin, who is only 1.5 years old, not being seen at home. She, Luthia Surin, told that since evenings he was not at home. Then both of us, along with some co-visitors, make a search for our son, but we could not trace him out. Around 5:30 a.m. today, on 31/3/2017, when both of us were searching him again, I got suspicious about my wife, and then I followed her. I saw her concealing the dead body of her son in a small pit by covering it with leaves and branches near a small jackfruit tree beside our house. Going to the place, I recovered the dead body of my child. When I started crying aloud, our co-villagers gathered at the place. When questioned, my wife confessed that she had killed our 1.5 years old son, Powell Surin, by pouring hot water on his person and by hitting him hard on his forehead with a stone. I therefore request you to take necessary legal action against my wife for killing our son and oblige. This is the affair, my lord. Incident happened, my lord, previous day. Well, then your lordship,
Just a
my
minute,
lord,
just a
deposit.
Just a minute. Just a minute. The Ajahar was received at 8:30 a.m.
8:30 a.m.
They got the 5:30 a.m.
5:30 a.m.
In the morning, he recovered the body.
body. An incident of this, my lord, previous day, at the 30th
Evening.
evening. I'll then come to my lord, your lordship, deposition.
Just a minute. How many charges?
Charges, my lord, 2, my lord, 302 and 201. That is the page 7.
Two heads. Two heads.
2.
302
Page
and
6.
201. Disappearance of evidence.
At page 8, deposition of
PW1.
PW1.
Informant.
Yes, sir. May I read it?
Please.
I know the accused who is my wife. Deceased Powell Surin was my son, who was aged 1.5 years at the time of his death. I had lost the affair before Jamuguri PS. The occurrence took place about 8 months ago. On the date of occurrence, at about 3 p.m., I had brought rice and biscuits to my house. My son was eating biscuit at the time. I had noticed that my wife, the accused, used to boil water, and on being asked, she has stated that he was making the boiled water for the purpose of bathing herself as well as my minor son. Thereafter, I have left for playing volleyball. I have returned to my house at about 6 p.m. and on being asked about my son, the accused has stated that she could not find out my son. I have searched for my son but could not find out on that night. On the next day also, I had searched for my son in the well and towards the paddy field, but I could not find him. At the time, I had noticed that my wife, the accused, had been trying to hide something with the garbage. On being asked, she had stated that she went for Nestor's call. I had smelled foul play, and on being removal of the garbage, I found the dead body of my minor son and came to know that the accused had killed him and hid the dead body below the garbage. Thereafter, I had called the nearby villagers, Ismail and many other people has gathered. Thereafter, I lodged an FIR before police. Police had conducted post-mortem, exhibit 1 as the FIR, wherein I had put my thumb impression. Police had prepared the inquest over the dead body of my son. The accused has stated before police in presence of me and others that she had killed my son by pouring boiled water and also thereafter by throwing stones upon him. Police had also brought me to the court where my statement under section 164 CRPC was recorded. I have stated before the magistrate, the above person. Exhibit 2 is my statement under section 164 CRPC when I put my thumb impression. And it's cross, your lordship. It is not a fact that I have not stated before police that I had noticed that my wife, the accused, used to boil water and on being asked, she has stated that she was making the boiled water for the purpose of bathing herself as well as my minor son. I have not seen personally as to how my son died. The accused did not take proper care of my said son and used to feed him. I had recovered the dead body of my son, which was kept hiding below the garbage. After recovery of the dead body, I brought the dead body of my son to my courtyard, and their nearby people gathered by hearing my shouting. And then I told them that the accused had killed my son. Then the public had assaulted the accused, and the accused was handed over to police. My lord, this is very important. It is not a fact that the accused had not killed by my son by pouring water and by throwing stone. It is not a fact that I have implicated the accused out of suspicion. Ismail had reached my courtyard when I brought the dead body to my court. Now, your lordship is deposition at 10. Here is my lord PW1. One thing
Ismail is PW2.
PW. May I read it, your lordship?
Just a minute. Yes, please.
I know the accused. I also know the informant who is the husband of the accused. I knew a deceased Paul Surin, who was the son of the informant and the accused. The occurrence took place about 7-8 months back. On the date of occurrence, about 6 p.m., while the informant returned after playing volleyball and asked the accused about his son. The accused replied that her minor son was not found in the house. The informant was crying, and then I, alone with her villagers, went to his house. We all searched for the minor son, but could not trace him out. On the next morning at about 5 a.m., the informant had found the dead body of his minor son on the backside of his house near the tree, which was hiding below the garbage. Hearing the crying of the informant, the villagers gathered. I had also gone to the house of the informant. I had seen the dead body of the minor son with burning injuries. I had also noticed injuries on his head. The accused had stated before the villagers, including me, that she had poured boiled water upon her son and killed her son. The villagers had informed police, and police came to the place of occurrence. Police had prepared the inquest over the dead body. I put my signature on the inquest. Exhibit 3 is the inquest, wherein Exhibit 3.1 is my signature. Police had taken away the dead body for post-mortem examination and also arrested the accused. Police had brought me to court wherein my statement under section 164 of CRPC was recorded. Exhibit 4 is my statement, wherein Exhibit 4.1, Exhibit 4.2 are my signatures. And cross, your lordship. Cross is very, he is a hearsay evidence. Ultimately, he is admitted. I came to know from the informant that on his return to his house, he had thirst for his son, but could not find him. The villagers had assaulted the accused, and then she had stated that she had killed her son. My lord, this is very important. That part, my lord, I am coming later on, my lord. I have not seen as to how Balfirin died. Then deposition number 3, my lord, PW3, is, well, it's Noah's parents. Noah's parents. Very detailed. May I read it?
Please.
I know the accused. I also know the informant who is the husband of the accused. I knew deceased Powell Surin, who was the son of the informant and accused. The occurrence took place on 33/2017. On the date of occurrence at about 7:30 p.m., the minor son, as at about 1.5 years, was missing. On being searched, he was not found. On the next day at about 5:30 a.m., the informant saw his wife, the accused, near the jackfruit tree doing something there. On being asked, she could not reply properly. On suspicion, the informant went to the place and saw that the dead body of the minor son was hiding below a garbage, etc., near the jackfruit tree, where the accused was doing something. The informant met Allah. While hearing Allah, I came to the house of the informant. Many people gathered here. On being asked, the accused had confessed before us and villagers that she had killed her minor son by pouring hot water and also by striking by means of a stone. We have seen burning spots on the dead body of state minor boy. Thereafter, police also came and the accused person had also confessed before police in our presence and stated the same thing. Police seized the stone. Police had prepared the inquest over the dead body, wherein I put my signature as witness. Exhibit 3 is the inquest, wherein Exhibit 3(2) is my signature. Police brought me to the court, and magistrate had recorded my statements under section 164 of CRPC. Exhibit 5 is the said statement, wherein Exhibit 5(1) and 5(2) are my signature. Then your lordship is crossed, my lord. I have not stated before the police that on the next day at about 5:30 a.m., the informant saw his wife, the accused, near the jackfruit tree doing something there. On being asked, she could not reply properly, and on suspicion, the informant went to the place and saw the dead body of the minor son was hiding below the garbage, etc., near the state jackfruit tree, where when the accused was doing something. I have not seen the accused doing something near the jackfruit tree. I have heard about the same from the informant only. Here's the evidence only. Same. Public had assaulted the accused due to aforesaid crime. It is not a fact that by assaulting the accused, we have compelled her to confess falsely in respect of the crime. After the informant making halla and after recovery of the dead body of his minor son, we, the public, gathered in his house. I have not personally seen or have no personal knowledge in respect of killing the minor boy by the accused by means of hot water, etc. Police had seized his stone from the courtyard of the informant. Said stone was bloodstained. It is not a fact that there was no bloodstain in the said stone. Police had not taken my signature on the seizure list. Next is, my lord, deposition of PW4, my lord. 3 on Nag. May I read it, your
Just a minute. He's a carpenter
Yes, sir.
of that locality.
Yes, sir.
Yes, please.
I know the accused. I also know the informant who is the husband of the accused. I knew this is Powell Surin, who was the son of the informant and the accused. The occurrence took place on 33/2017. On the date of occurrence at about 7:30 p.m., the minor son, as at about 1.5 years, was missing. And on being searched, he was not found till 11 p.m. night. On the next day at about 5:30 a.m., the informant saw his wife, the accused, near the jackfruit tree doing something there. On being asked, she could not reply properly, and on suspicion, the informant went to the place and saw that the body of his minor son was hiding below garbage, etc. near the Jackpot tree, where the accused was doing something. Informant and Halla. Hearing Halla, I came to the house of the informant. Many people gathered there. On being asked, the accused had confessed before us and villagers that she had killed her minor son by pouring hot water and also by striking by means of a stone. We have seen burning spot on dead body of the state minor boy. Thereafter, police also came and deviated, my lord, that it was not, confession was not before the police also. The accused person had also confessed before police in our presence and started the same thing. Police had prepared the inquest over the dead body. Thereafter, I put my signature as witness. Exhibit 3 is the inquest wherein Exhibit 3 is my signature. Police brought me to the court and magistrate had recorded my statement under Section 164 of CRPC. And Exhibit 6 is the safe statement wherein Exhibit 6.1 and 6.2 are my signatures. His statements were quite different from the others. He said that initially he confessed before the villager. Thereafter, again she confessed before the police.
No, PW3 has also said the same.
Before the villagers.
PW3.
Yes, before the village.
Same thing.
Cross,
No,
my lord.
PW3 in the page 12. Middle part, Halla. During Halla.
Yes, during hearing Halla, I came to the house.
Many people gathered
Gathered. On being asked, the accused had confessed before us. Yes,
before us, and the villager that she had killed so and so.
Sir.
Thereafter,
Thereafter,
police also came and same thing.
Same. 3 and 4. Then cross, my lord. I have not seen personally in respect of killing of the minor boy by means of a hot water and stone. It is not a fact that by assaulting the accused, we have compelled her to confess falsely in respect of crime. It is not a fact that the accused had not killed her son. It is not a fact that we have falsely implicated her and forced her to confess. Then, your lordship, PW5, Osupwala. He's a student, your lord. In fact, he was at that time. I don't know.
Not personally seeing the incident, this is not a question to be asked in the cross. One in the chief, she has not even claimed to be an eyewitness.
Yes, sir.
Now, putting this kind of question in the cross
Yes,
is
sir.
in fact a risk. If she would have said, yes, I have seen, what do you do then?
Yes, Lord. Nobody is eyewitness. That is it. That also irrelevant question to that context.
16.
Peter reply is the Ashok Gwala, my lord.
Who is 5?
Ashok Gwala, student, was a student. At that point of time, he was a student. I don't know at that point.
Maybe he is in the neighborhood or something.
Yes.
Like
Same, my lord. Ramuguri, Palizuli, same area.
Yes, please.
I know the accused. I also know the informant who is the husband of the accused. I knew this is Powell Surin, who was the son of the informant and the accused. The occurrence took place on 30/3/2017. On the date of occurrence at about 7:30 p.m., the minor son, as at about 7-8 months, was missing. On being searched, he was not found till 11 p.m. on that night. On the next day at about 5:36 a.m., the informant met Allah, and hearing the Allah came to the place. The informant told that his son was killed by his wife and kept under the garbage near the tree. Police also came and seized one stone from the backside of the house of the accused informant. I put my signature on the Caesar list as the witness. This is Caesar witness. My lord, and the thing is that, my lord, this statement was not stated by him. Same, some hair and blood stain here on the said stone. I have not seen personally how the minor boy died. It is not a fact that the public had threatened the accused and being threatened, he was compelled to confess. Basically, he is a my lord Caesar.
Just a minute.
Then next, my lord, is
Just a minute, just a
PWC.
minute, just a minute, just a minute, just a minute. PW6 is a cultivator.
Yes, sir, cultivator. Shravan Nag.
Yes.
I know the accused. I also know the informant who is the husband of the accused. The occurrence took place on 33/2017. On the next day of occurrence, at about 10 a.m., I saw villagers and police gathered in the house of the accused. I also went to the police and also saw the accused. Here, I also saw the dead body of Paul Srin, the minor son of the accused. On being asked, the accused has stated before the villagers and police that she had killed her minor son. She had stated that she had killed her son by pouring hot water and also by assaulting a stone. Cross, my lord. I have not stated before police that the accused had stated before the villagers and police that she had killed her minor son by pouring hot water, and also by assaulting with a stone. I have not personally seen as to how Palsurin died. I was not present at that time. I went to the house of the accused on 31/3/2007 at about 10 a.m. It is not a fact that the villagers had assaulted the accused and forcefully implicated her in respect of death of the minor. Dan PW7, Johan Murmu.
Who is also a cultivator.
Cultivator.
Yes, please.
I know the accused. I also know the informant who is the husband of the accused. The occurrence took place on 33/2017. On that day, in the evening hours, we have heard some halla and also heard that the minor son of the informant got missing. The informant also informed the matter to the VDP secretary or of our village. The evening, police and VDP personnel had inquired about the missing boy but could not find. This is my lord new aspect. My lord has added. It was not stated by any of the my lord PWs or the PW1 also. On the next day morning at about 6:30 a.m., I went to the place of occurrence and saw the dead body of Paul Surin, the minor son of the accused. The said dead body of the minor was kept hiding beneath the near earth near a jackfruit tree. On being asked by the villagers, the accused has stated before me and the villagers that she had killed her said minor son. I have seen stone with blood stain at the place of occurrence. Police has seized the said stone from the place of occurrence. Exhibit C is the scissor list, where Exhibit 7-2 is my signature. Material Exhibit 1 is the said seized stone. Then cross your lordship. I have not stated the above person before police. Today I have stated for the first time in the court. Police had seized the said stone, material Exhibit 1 from the said side of the wall of the house of the accused. Exhibit 7-2 was taken at the place of occurrence by police. A new version has been added, but it is not stated before police. Next is my lord exhibit deposition of PW8 Tin Huzur. The laborer. And my lord, this evidence, my lord, I find a little hints from this evidence, my lord. That might be the, my lord, aspect of the matter, my lord. Here evidence, may I read it, your lordship?
Just a minute, please. He is also from the locality.
Local. Only, my lord, this witness stated, my lord, this thing. May I read it?
Yes, yes.
I know the accused.
Doctor,
No, my lord, that PW8,
yes, eight you have read. Okay.
only one aspect, my lord, that which.
Which, yes.
That is the aspect, my lord. Because these areas are, my lord, famous for that.
What is
Okay.
a Golgotha?
Kolkata. Sarkatak.
He cuts the neck or what? Or his neck is cut without a neck.
My lord, yes, MO, that Dr. Ranjan Kumar Das. May I read it, your lord?
Please.
On 31/3/2017, I was posted as Senior Medical and Health Officer, Konoklota Civil Hospital, Tezpur. On that day, I conducted post-mortem on the dead body of the Payal Soren, 1.5 years old, male, son of Sri Bhushan Soren of number 5, Jaipur, Pansmukh, under Jamugri PS, identified by UPC 824, Devan Hazarika in reference to Jamugri PS case number 35 of 2007 under section 302 of IPC. On examination, I found the following. A dead body of a male child with rigor mortis present, eyes and mouth closed, peeling of skin on the whole body due to pouring of hot water, a sharp cut mark on the right side of the forehead, size was 3 centimeter into 3 centimeter into 2 centimeter. Hematoma seen on the brain on right parietal lobe, size was 6 centimeter, 4 centimeter, 3 centimeter. Fracture of the right parietal bone seen, Time of injury was approximate 6 p.m. on 33/2017. These injuries were ante-mortem in nature, involving 95% burn. In my opinion, the cause of death was due to hemorrhage as well as neurogenic shock. Exhibit 8 is the post-mortem report, wherein Exhibit 8.1 is my signature and Exhibit 8.2 is the signature of Dr. Zuri Bhattacharjee, then Joint Director of Health Services, Sunitpur, Tezpur, which I know. Cross my lord, only one question. The sharp cut mark may only be caused by sharp weapon. The cause of death is cumulative effect of cut injuries as well as burning. Daniel Ayo, Raju Bahadur Chetri, SI. Married.
Ken.
Ken.
Ayu.
Ayo.
Please read.
I know the accused present in the dock. On 31/3/2017, I was posted as OC, Dharmaguri PS. On that day, I received a written FIR from Vincent Surin, alleging that on 3/33/2017, after coming to house from volleyball field, she could locate his 1.5-year-old son. On query, his wife, the accused, said that she do not know whereabouts of her son. Then informant, along with her other villagers, searched for the boy but could not find. On 31/3/2017 morning, the informant suspected his wife and started following her. Informant could notice that the accused of the wife went towards a jackfruit tree and concealing something under dry leaves and residues of trees. The informant went to the place and noticed the dead body of his son is concealed inside the pipes and dry leaves and branches. On making when cry, gold villagers came to the place and questioned the accused. The accused then admitted that on previous day, they first poured hot water on the person, on her son, and thereafter with stone hit him on the head. As a result, her son died. Thereafter, she concealed the dead body near the jackfruit tree. After receiving FIR, I registered the same as Dharmaguri PS case number under section 302 IPC and started investigation. I made a GD entry number 713 dated 31/3/2017. I recorded statement of informant. Thereafter, I visited the place of the occurrence of village number 5 once more. I recorded statement of the witnesses and prepared sketch map and of the place of occurrence. I found the accused and apprehended her. Exhibit 9 is sketch map and Exhibit 9.1 is my signature. And Exhibit 9.2 and 9.3 are the place of occurrence. I prepared the inquest report of dead body in presence of witnesses. Exhibit 3 is the inquest report and Exhibit 3.4 is my signature. I noticed mark of injuries on the head and body of the deceased boy. And being led by accused, I recovered and seized the stone by which the accused hit her son and caused his death. Exhibit 7 is the scissor list of weapon, and Exhibit 7.4 is my signature. Accused also put her thumb impression in Exhibit 7. I prepared a salan and sent the dead body for post-mortem examination. Exhibit 10 is the dead body salan. During investigation, I collected the post-mortem examination report. Exhibit 8 is the post-mortem report. After completion of investigation and finding sufficient materials against the accused, I filed charge sheet under section 302 of the 201 of IPC. Exhibit 11 is the charge sheet and Exhibit 11.1 is my signature. Exhibit 1 is the Izhar and Exhibit 1.1 is my signature. And across my note. I have not recovered dead body, but recovered by the informant initially. It is not fact that the people severely assaulted the accused and detained her. I found the accused being detained by the villagers. It is not a fact that I stated falsely that accused led me to the stone by which she hit her son. It is not a fact that, in fact, Vincent Surin produced the stone. I have not inquired as to who wrote the FIR, as there is some impression of Vincent Surin. It is not a fact that I have not properly investigated the case. It is not a fact that the accused is not involved in the murder of her son and she has been implicated falsely. my lord, then the 313 statements of the accused, my lord, at page 24. Everywhere, every question, she said it's a fact, it is a fact, it is a fact. She did not deny anything. Last page, my lord, 27, my lord. Question number 17 only, my lord. I find this, my lord, quite relevant.
Seventeen.
70. I killed my son, but I do not know why I committed such act. Well, in this case,
Yes.
unfortunate incident happened, my lord. That is the truth. One thing is the, my lord, missing is because it is not a case of eyewitness. It is a circumstantial evidence. Now, what is the intent? Intent of the mother, my lord, kill a son. There has to be some intent. And from her own statement, it appears that he did not know also. The second thing is that, my lord, if she confessed, my lord, why her confessional statement was not recorded under section 164, my lord? All the, my lord, witnesses were examined under 164. They were not eyewitnesses. Their statements, my lord, under 164 may not be very relevant. Now, the next question is that stone, that the murder weapon, my lord, whether fingerprint was taken? No fingerprint was taken. Then PW5 said some hair and blood was seen in the stone. Then it was not, my lord, sent to forensic, my lord. Whose blood and whose hair is there? Nothing. And in this case, my lord, because he is a murderer, my lord, that intent is very much required. And without the intent, my lord, that cannot be, my lord. Nobody came to the conclusion. Now, this trial court came to the conclusion. Well, since, my lord, she admitted, she confessed in his 313 statement, she was convicted. Only basis of 313 statements is his mental condition also may not be such like that, because from the exhibit, from the PWA, it appears that he might be treated as a witch, my lord. I don't know what is the, my lord, came behind all these things, because only PWA, my lord, that has stated that thing, my lord. And to kill, my lord, son, his own son, my lord, that is only son, and is 1.5 years old, without any reason, without any intent, my lord, why she will kill? To go behind the bar, my lord. This aspect was not, my lord, considered by the trial court, my lord. It was ignored. That's why I'm saying, my lord, if it appears, my lord, during the trial also, maybe it was not taken by the defense, my lord, the defense, but she was not in a state of mind to take the defense also. Is it not a duty of the court, my lord? Under section 329 of CRPC, my lord.
What is 329?
Yes, the lord. Yes. CRPC. Purna. Have I got?
Yes, please read.
Yes. If at the trial of any person before a magistrate or court of session,
Hmm.
it appears to the magistrate or court, this person is of unsound mind and consequently incapable of making his defense, the magistrate or court shall, in the first instance, try the fact of such unsoundness and incapacity, and if the magistrate or court, after considering such medical and other evidence as may be produced before him, or it is satisfied of the fact, he or it shall record it a finding to that effect and shall postpone further proceeding in the case. And this 1A is, my lord, inserted, my lord. If during trial a magistrate or court of session finds the accused to be of unsound mind, he or it shall refer such person to a psychiatrist or clinical psychologist for care and
Now,
treatment. And this psychiatrist,
to bring home this 329, what are the materials?
materials, my lord, 313, this is the only, my lord, situation where, my lord, there's a direct interaction between this, my lord, accused and the court. Enter, my lord,
The only material which you are trying to borrow from the 313 is question number, response to question number
other
17.
question also. Other question is he admitted.
Admit,
He did not deny anything. He
No.
confessed, my lord, whatever said, or he confessed. My lord, probably he did not know also what the witnesses said before the police or the court.
will that be
It is-
enough?
it is-
Will it be enough to bring in the aspect of mental unsoundness?
It may not be, my lord, if she would not, she had it at, my lord, she,
No, any of
is
the
the mother of the,
witness-
my lord.
any of
Right.
the witnesses have made any statement regarding any unsoundness on her part or unnatural behavior?
PWs, all PWs are against this, my lord, appellant. So
Not a question, it's not a question of being appellant. Either in the
that
chief.
which and one PW1, my lord, one fact, my lord, in cross examination, your lordship may clearly see, maybe that your lordship may kindly see cross of the PW1 at page 9.
Please read.
My lord,
Page
1, 2,
9.
3, 4, fourth line.
Yes, please.
The accused did not take proper care to my said son and used to feed him. So it is, my lord, highly my lord, impossible. The mother will not, my lord, take care of a child, and my lord, kill a child 1.5 years without any reason, my lord. That aspect of matter, my lord, was hurting on me, my lord. That yesterday also, night also, when I was reading
No,
all
there are no other materials even to give a feeble suggestion that somebody else was involved.
my lord, everybody was maybe she was treated as a witch because PW8 has stated all these things. But only
You
PW.
read 8 again. 8 has not even given a remote hint that this appellant was treated was regarded as a witch or something. He said that there was a halla in the evening.
Which has come to our village. That is the thing.
which is
Which has come.
no, please read 8 again.
Yes, your lord.
And 8 is the solitary witness on that in that regard. I don't think that would be relevant.
My lord, at page
Wait.
19.
1919, yes, please.
On the second line, on the day of occurrence in the evening hours, we have heard Allah in the village that some witches, Kolkata, are coming to the village.
Are coming. And not has come.
My lord, translation, right? Original, I have not
It's
seen.
not translation. It is not translation. It is
It's
recording.
original.
Original. Which are coming.
Coming, maybe coming this date, that
That will not even remotely
Yes.
mean that this appellant
But,
was a witch or regarded as a witch or
but,
anything like
but
that.
the intent, even is, my lord, in spite of all these things also, my lord, that intent,
Motive.
where is it?
Motive. That,
Yes, all of not, there is a definition, my lord, of the apex court, my lord, with effect.
please read. Please.
My lord, I am
citation,
sorry, one.
Citation.
That is 1976 to SCC 788.
6 to STC.
To SCC
7.
788.
You should have given the citation. We would have taken the prints.
One
You-
copy, my lord.
No,
I'm
you-
extremely sorry, my lord.
would have taken the prints of the relevant paragraphs.
Yes, Lord. Paragraph 33, my
Name Jayaraj.
Jairaj.
Paragraph.
Paragraph 32 and 30. 32, my lord, first 32, then 33, my lord.
What is there?
For this purpose, we have to go to section 299, which defines culpable homicide. This offense consists in the doing of an act with the intention of causing death, or with the intention of causing such bodily injury as is likely to cause death, or with the knowledge that the act is likely to cause death. As was pointed out by this court in Anda versus State of Rajasthan, intent and knowledge in the ingredients of section 299 postulate that the existence of positive mental attitude, and this mental condition is the special mens rea necessary for the offense. The guilty intention in the first two condition contemplates the intended death of the person harmed, or the intentional causing of an injury likely to cause death. The knowledge in the third condition contemplates knowledge of the likelihood of the death of the person. The first clause of the section 300 reproduces the first part of section 299. Therefore, ordinarily, if the case comes within clause A of section 299, it would amount to murder. However, if one of the special exceptions in section 300 applies, the offense would be culpable homicide, not amount to murder. Such is not the case before us. So that is a, my lord, his knowledge is not there, my lord. Her knowledge is not there.
No.
Intention is
Intention is another matter. More knowledge is another.
intent is also not
You
there.
may not have the. But if you are pouring boiling water on a 1.5
What
year.
is the intent, man?
No, that is different matter.
Yes, sir.
Knowledge is different.
Yes, sir. Yes, sir.
Knowledge is
That's
what,
why, my lord, it came to my mind that pouring boiled water over my lord, his own son,
her own son.
my lord, it reflects her mental condition, man. If it's really true, man. If somebody is involved, I don't know, because nobody, my lord, no materials is there.
No, in
I
the
know.
case of state of that Rajasthan case, Anda case,
Yeah.
that was on the aspect of how do you bring in the, how do you differentiate between an offense which comes under 299, an offense
300.
which comes under the ambit of 300, and when
Exception
culpable
is
homicide
not
will
about
will amount to murder and one it will not amount to murder.
here, my lord, I think, my lord, this is, even if we just, my lord, accumulate all the, my lord, everything, all the evidence and goes against the accused, goes against the appellant, my lord, I don't think it is a murder. First aspect is that there is a murder of the, my lord, child, and no murder, my lord, can kill a
No, that
son
is an assumption.
without any knowledge, without any
That is an
intention,
assumption.
without any
See,
intent.
1.5 year pouring hot water, boiling water.
That's
and
the
saying that no.
unfortunate, very unfortunate
See,
incident. That is,
299 and 300, if you.
my lord, that's a very unfortunate incident that I know, my lord.
No, we are
That
not
is,
on the unfortunate part. We are on the factual part. Read 304thly. Even assuming that your
300,
argument on intention
304, my lord.
fourthly. For 300 fourthly.
4?
Fourthly.
Acha,
300,
fourthly.
section 300.
Acha, acha, 300, section 304.
Yeah, fourthly.
Yes. Exception, my lord.
Not exception. The fourthly, there are 4 provisions in 300.
Yes. Oh, yes. If the person committing the act knows that it is so imminently dangerous that it must, in all probability, cause death or such bodily injury, as is
likely to
likely to
death.
cause death and commits such act without any excuse for incurring the risk of causing death or such injury or forfeit.
1.5-year child.
My lord, if
95%.
my lord, if we see the incident, that obviously, my lord, we are against the appellant. But my lord, that aspect has to be, my lord, taken into mind. My lord, this mother and killing his own son without any reason, my lord, without any no intent, no criminal intent, my lord. Why?
That is the reason we are trying to bring in fourthly. The first, second, third are on the intention part. Fourth is on the knowledge part.
But that is also not covered, my
Why?
lord. He said I don't know. Why kill?
Why I have killed, I do not know. But has he said that I do not know that if I pour boiling water on my 1.5-year-old son, I did not know
That's
that,
why, my lord,
that he would die.
pouring and my lord,
95% burned.
yes, my lord, pouring hot
And
water.
that stone has
that-
not, probably the stone did not cause the death. That was not necessary. This burn
My lord,
itself
pouring
caused the death.
hot water, my lord, that I think that incident, if you look at an incident, that's why I'm saying, my lord, if you look at an incident, my lord, obviously appellant has no case. But pouring a hot water of, my lord, over a, my lord, the body of a, my lord, 1.5-year child by her mother, by his mother, my lord, by his mother, that aspect, my lord,
Okay.
without any intent.
Anything else?
My lord, that is.
Yes, madam.
There is nothing much to say here. The circumstances, as I can see, is first of all, she was already boiling water in the morning when the husband went out. And when the husband asked, then she said that I was boiling water to bathe
No,
my
not in
body.
the morning, in the evening.
In the afternoon, yes.
Evening,
in
when
the,
he had gone for playing volleyball.
when he had gone to play volleyball, yes. So he went to play volleyball after that, and he told his wife also that I'll go to volleyball, and then 5 p.m. he goes to play volleyball. He came back, he did not find his son there. He asked his wife said that I do not know where he is. Thereafter, they searched till 11 o'clock at night. He was not there. And mother was also not keen in searching and all. Of course, that is not there in the evidence. Morning, he went to the well to search whether he had been drowned there. And then he suspected his wife. He followed her. He saw her beside that jackfruit tree doing something with the garbage. He shouted. People came. And in the presence of the public, the body was taken out. Body was brought to the courtyard. And then the accused confessed before the public. Thereafter, police was informed. Police came. Again, she confessed before all. So these circumstances do make out a case against her. There is no doubt about it. And there are more circumstances like the confession. It tallies with the PM report. She said that I had poured boiling water on him and I had used a stone and hit him hard. And that corroborates the medical opinion, which says cumulative effect of both boiling water and the stone hitting. Cause of death, Lordship can see, the doctor said it is a cumulative effect of both the assault. So here and then the seizure of stone, not a 27 recovery, it was lying open in the field, but then it was shown by her and it had blood stain and hair. Hair will be there because it was hit on the head of the child and the hair was there. And 313, she admitted. She said it's a fact. And then she said also in her defense that I had killed my son. Of course, she was, there was a prayer made for judicial confession. Motive is, of course, not there. But then I have a decision of Supreme Court where it is said if the circumstances are strong, even in absence of motive in a circumstantial evidence case, will not be fit.
Normally, if there is an eyewitness, we do not look for motive.
That is not.
But circumstantial evidence, motive is one of the circumstances.
Circumstantial.
Normally.
Lordship will see that decision once. if the circumstances are very strong.
Let us see. Which
That is 2008-5. Yeah, no, this is paragraph 87. Don't take out the entire one.
page,
2008-5-587.
name,
Name is Ramanand alias Nandlal Bhar. Stick. Nandlal Bharti. Ramanand alias Nandlal Bharti, page, paragraph 87. But this is, of course, very strange. As my learned friend said, a mother will not kill her own child 1.5 years. But unsoundness of mind and all, Lordship knows that if somebody wants to build up a case on unsoundness of mind, he has to prove it, either by way of medical testimony or by or by evidence or witnesses' testimony or by judicial inquiry. None of these factors are there. Unsoundness of mind is nowhere established in this particular case. Page number, paragraph 87, Lordship will see. It is a settled principle of criminal jurisprudence. Lordship got that paragraph?
yes.
Yeah. That in a case based on a circumstantial evidence, motive for committing the crime on the part of the accused assumes greater importance. This court in various decisions has laid down the principles holding that motive for commission of offense no doubt assumes greater importance in cases resting on circumstantial evidence than those in which direct evidence regarding commission of offense is available. It is equally true that failure to prove motive in cases resting on circumstantial evidence is not fatal by itself. However, it is also well settled that it is right in law that absence of motive could be a missing link of incriminating circumstances. But, again there is a rider, but once the prosecution has established the other incriminating circumstances to its entirety, absence of motive will not give any benefit to the
It's moldable.
moldable.
There is no hard and fast.
No hard and fast.
You
All
look
depends
into
on.
the other circumstances. Merely because motive is absent
Hmm,
in a case of circumstantial evidence will not make the prosecution case fatal.
yes.
That is the law.
Hmm.
But normally you look for motive.
Well, normally, there's a missing link, as it is said.
Yes.
But here, Lordship will see the circumstances. It makes out a complete case. Although in a very in a sad heart, we'll have to say, it makes out. She was, of course, she was boiling water. Maybe she was actually boiling water for some other purpose. But then after she was found digging up something near the jackfruit tree, she was found hiding something near that. And when husband suspected, then why this suspicion came, I don't know. No husband will suspect his wife that she would kill. Maybe that which part is there as a fact. I don't know. That has not come in the evidence, barring only one sentence, or some which had come.
No, not had come. Which was coming.
Which was coming. Nobody said that she was erased, she was branded as a witch or anything.
Was any broom seized?
No. Broom is a very important part.
If witch is there, broom has to be there.
Has to be there.
How do you travel otherwise?
No broom seized.
Mode of transport.
Yes. So, in a way, and then after that, she was hiding then. And it's that when the body was brought out, public was there, people were there, neighbors were there. And then she said before everyone, and she admitted that. And everyone had stated the same. I don't find any loopholes in between.
Unfortunate.
Unfortunate, very unfortunate. Had there been something that would have been converted into 304, that is, Lordship had said that fourthly, but then fourthly, that knowledge is also there. But without any excuse, I think fourthly it is written without any excuse. He didn't reveal any reason, any excuses. Why take it?
There are many of cases of nature of where conversion is possible. We have tried to convert because of post-conduct and immediate remorse. Here, it was concealed.
It was concealed.
So good.
And
Once the
outside my-
concealment part comes, that means you are aware that your act is
Hmm,
either contrary to law or wrong.
yes,
Otherwise, why should you conceal? You know you have done a bad thing. Conceal it.
she knew the consequences. So 299 will not come. But then again, keeping her inside jail for the life is also not be very fair. An extrajudicial confession, Lordship can see one decision on that. 2012 6 SCC, that I have not given. I'll just
2012.
12 6 SCC 403. This is a case on under what circumstances this extrajudicial confession, although it's a weak piece, that can be relied on.
A paragraph.
Paragraph I have not taken on.
Name.
Name is Sahadevan. I'll give the paragraph. Sahadevan versus State of Tamil Nadu.
Yes.
This is an extrajudicial. This will be paragraph. This is paragraph 22. Principle which makes an extrajudicial confession an admissible piece of evidence capable of forming the basis of conviction of an accused. Paragraph 22 in Supreme today law.
No, there are many decisions. It's a weak
think
piece,
many-
weak piece of evidence, but
It's a weak piece
it
of
can
It's said to be proved beyond all
it
reason.
can be certainly a link to the
This
circumstances.
can be a link. This will be a link. So paragraph 21.
Yes.
This extrajudicial confession is a weak piece. It has to be examined by court. It should be made voluntarily and should be truthful. There is no injury and nobody had assaulted her. So here in this
No,
case,
there
it
are
is,
materials of assault. Public had assaulted.
uh,
I do
few
not know whether she was taken for medical. Did the IO say?
I did
IO has
not
not
say
said anything that she was taken for medical.
medical. It should inspire confidence. An extrajudicial confession attains greater credibility and evidentiary value if it is supported by a chain of cogent circumstances. It cannot be, it has to be supported by other strong circumstances and is further corroborated by other prosecution evidence. For an extrajudicial confession to be the basis, it should not suffer from any material discrepancies. Such statement essentially has to be proved like any other fact and in accordance with law. So if it is backed by other strong circumstances, then this will also become a link. So what can I say? These are my humble submission, these circumstances that I have found. Or conversion is little difficult. I don't find any way.
Yes. Okay.
Sure.
Anything more? Sharma, amicus. Amicus.
Yes, sir.
Jahan ne bhi put. Okay, we'll consider. No, seriously. Hmm. 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 No, there is no material going to discuss of he is suffering from any answer. He's trying to make a kitchen 3 months admission. Admission is not will not be answer of mine. So Kulta as amicus.
Lordship,
Yes, you'd be appealing.
Sir.
Conviction under
302, Lord.
appealing to Sarjan Mura. Yes, please.
Yes, Lordship, the FIR is at, starts for page 1 only. This incident happened on 2010-2014. FIR was filed on 2010-2014. Incident happened on 19-10-2014 at 9 p.m. The main content Lordship will find at page 4.
Yes, please.
Page 4, Lordship. May I read out, Lordship?
Yes.
Humble submission is that on 19-10-2014, Sri Sajan Mura, son of Manik Mura, a resident of line number 12 of Rankam Tea Estate, assaulted my younger sister Anima Mura. We came to know that prior to this incident, since 1 month after their marriage, he had assaulted my younger sister. My younger sister was carrying a pregnancy of 3 months. At about 9 p.m. last night, he assaulted my younger sister again, and as a result of which she sustained grievous injury. On being received the information, we went to see her. We found her dead. After committing the incident, he tried to escape, but the local public caught him and handed him over to the police station. He confessed that he had assaulted my younger sister and she died as a result. So basically, Lordship, it's a case of circumstantial evidence and taking into account extrajudicial confession also. So there is a statement that Azahar is written as per the version of the informant and read over the same to him. Why I'm saying so, Lordship, is that like later on, he says that he doesn't know anything about the contents of the affair. Then Lordship may directly come to page 9. Page 9 is the deposition of witness. Prosecution of witness.
This Ajahar was lost on 2010-2014. At what time?
It was lost at 9. It was done at 10:30 a.m.
Morning.
morning. The incident happened the previous night at 9
9
p.m.
o'clock.
Right. And informant is the brother-in-law of the accused. So PW1 is the page 9.
Has he mentioned any, what kind of injuries?
Out here, Lordship, having the affair, nothing has been stated.
Grievous injury.
Only say the previous injury. Where exactly? I mean, nothing has been.
And PM says what? Injury?
Lordship,
PM says
PM says the injury on the head
by
by some blunt weapon,
blunt
blunt weapon. But that was not recovered. Page 9, Lordship. His name is Lalit Dandasi,
informant.
informed,
The
brother-in-law of the accused,
the charge was under 302.
302. Married her.
Yes.
Accused Sajan Mura is my brother-in-law. He married my sister Anima Dandasi about 1 year back. During the last year, after completion of Durga Puja, one boy from neighborhood of my sister informed me that my sister is in a serious condition and asked me to come immediately. So one boy has come and informed her. So one point is Lordship has to note down that this boy was not examined by the prosecution side. After getting the said information, I went to the house of my sister along with my mother and brother. So there are two brothers. So another brother accompanied them. After going to the house of my sister, I saw her lying dead on her bed. I noticed grievous injury on the left side of her eye. So this has to be noted, Lordship. I noticed grievous injury on the left side of her eye. That is
Yes.
the only injuries he has spoken about. During the time of incident, my sister was 3 months pregnant. When I went to the house of my sister, I found the accused in his house. On being asked him about the incident, the accused told us that he beat my sister and then gave her medicine. After the incident, I lodged the FIR at Selangaghat police outpost, wherein I put my thumb impression. After the information, police arrived at the place of occurrence and prepared inquest over the dead body of my sister in my presence. I put my thumb impression on the inquest report. As the accused beat my sister, therefore she died. I do not know to read and write. I do not know the contents of the FIR lodged by me. My sister was staying with the accused along with her father-in-law, mother-in-law, brother-in-law, sister-in-law in the same house. So it happened in a house where all her in-laws were residing. This is not a fact that accused did not tell me that he beat my sister and then gave her medicine. This is not a fact that my sister did not die due to the physical assault by the accused. So like other people were not examined. Other people, what I mean is that the in-laws, as well as the boy who was informed about the incident, as well as the other brother who accompanied. They were not exempt. And as far as the injury is concerned, Lordship may note that it's only, he said about the injury on the left side of her eye. That was the injury he saw. And sister was pregnant. PW2 Lordship at Page left. Malati Dandasi is the mother of the victim. Accused Sajid Mira is my son-in-law. He married my daughter Anima Dandasi about 1 year back. During the last year, after completion of Durga Puja, someone near the house of my daughter deceased informed me that my daughter is in a serious condition and asked me to come immediately. After getting the said information, I went to the house of my daughter along with my two sons. After going to the house of my daughter, I saw her lying dead on her bed and was having grievous injury on the left side of her eye. She also stated that injury is on the left side of her eye. During then, my daughter was 3 months pregnant. When I went to the home of the accused, he was present at his home. On being asked to the accused about the incident, he told us that as my daughter was not taking medicine, therefore he beat her. So this has been stated by both the brother as well as the mother, that the accused beat her because she was not taking medicine.
No,
The other one said that like I beat her, then gave her medicine.
that
And
was
so-
not the reason of beating,
That-
not taking medicine. This is by the PW2 that she was not taking medicine. Therefore, he had beat her.
Correct. This one person says that like she was not taking medicine, that because of that I beat her. The other person says that like I beat her, then I gave her medicine. Thereafter, my son lodged FIR at Selanghat police outpost. Accordingly, police arrived and did the inquest over the dead body in my presence. Exhibit 1 is the inquest report and Exhibit 1.1 is my signature. My daughter died due to the physical assault by the accused. Cross-examination part, Lordship, I did not state before the police that the accused told us that as my daughter was not having medicine, therefore he beat her. This is not a fact that my daughter did not die due to the physical assault by the accused. This is not a fact that my daughter died due to some disease. So more or less, like these two persons are almost similar. And the injury is on the left side of the eye. No other injuries was mentioned. And FIR also there was no injury specifically mentioned. But one thing comes out that like that the lady was pregnant 3 months. Page 13 is PW3. This is Dipali Mura. I know the accused Sajan Mura. I do not know the complainant. I knew this is Anima Mura. She was the wife of accused Sajan Mura. About 1 year back, I heard that the wife of the accused died at her home. I do not know how she died. At the time of the incident, I was not at home as I went to attend a marriage ceremony along with my daughter. I never saw the accused assault his wife. This may be noted, Lordship. I never saw the accused to assault his wife. Because, Lordship, in this case, that intent and all these things will come up later on.
No, where is her residence?
Residence is at Rakhan Bagan, line number 2.
No, she never seen, means has she claimed
She's
that?
a neighbor. It seems
No,
she's
no, from where is she stated?
No, she hasn't stated anything about this thing. As far as like, I never saw the accused assault his wife. It's in the bottom.
No, that we have seen.
Correct.
That is why I've asked
Huh.
whether she is in the vicinity.
No, that
think
doesn't
it's a
come, that
focus.
doesn't come from the record, but it says it's Rakhan Bagan, line number 2. So Rakhan Bagan, line number 2 is like I'm just like thinking that I'm just presuming that she must be a neighbor, but nowhere it has come
It
out.
doesn't appear because.
It doesn't, it hasn't come out
No,
from
no,
the record.
it doesn't be, why it doesn't appear, because if you come to page 30,
Page 30,
30,
yes, sir.
which is the examination under
313, yes,
313,
sir.
his residence of the appellant is Rakhari line 12.
Page
Even
30, Lordship, where Lordship is
30.
telling? Yeah.
My name is Sajan Mura. I am so and so.
Yeah.
My residence is village
Rakhagiri
Rakhari line.
line, Rakhagiri line.
Let us assume Rakhari and Rakhan Bagan is same,
Yes.
but it's line number 12.
Here line number 2 and here line number 12. Yes, Lord. That is correct, Lord. The Rongkhari line, number 12. And here is Rankhan Bagan, line number 2. But it hasn't come clearly, Lordship. That is correct. But he said specifically that I knew that this is Anima Mura and she was the wife of Sajan Mura. So they know each other. I mean, they were aware. And PW4, Lordship, at page 15. Manik Tapna Mura is the father of the accused. I know the accused Sajan Mura, he is my son. My son Sajan Mura, he's been declared hostile. My son Sajan Mura married Anima Mura about 3 years back. Anima Mura died by consuming some medicine which she consumed by herself. My son never inflicted any sort of torture on his wife. I was present while police did the inquest on the dead body Anima Mura. At this stage, prosecution paid for Tika and so he was declared hostile. The cross-examination by the prosecution, this is not a fact that I have stated before the police that since earlier my son used to beat Anima Mura. This is not a fact that I have stated before the police that on the previous night of the incident, after coming to home, I found my daughter-in-law, Anima Mura, in a critical condition. Thereafter, she died due to continuous assault by my son. This is not a fact that I have stated before the police that after coming to know about the death of Anima Mura, our family members came, and when the accused was tried to be apprehended, he fled away. This is not a fact that I have deposed falsely that Anima Mura died by consuming medicine. So he stated that he hasn't stated anything about the assault by his son to his wife before the police. Any past assault or the assault on the previous. Page 17, Lordship, PW5. His name is Joy Prakash Rajak. Father's name is Madan Ram Rajak. I have come to know about accused Sajan Mura after seeing him on the day of occurrence. I know this is Anima Mura. He used to reside in the same tea estate which I reside. Deceased was married to accused Sajan Mura. Accused used to make quarrel and torture on the deceased. This is his statement. On 19/10/2014, one Sajan Munda worked in the tea garden called me in the night at about 9 p.m. and asked me to go to the house of accused situated at line number 12 at Rongkham Tea Estate as one person had killed his wife. After coming to know about the said occurrence, I went to the said place. Accused Sajan Mura was absconding. So he says that he was absconding.
He was informed by Sajan Munda.
He's informed by one Sajan Munda. He's also one of the prosecution witness, Sajan Munda. And
the appellant is Sajan Mura.
Sajan Mura. And he says that he is reside in the same locality, same line. And he said that he did not know Sajan Mura. So this is little bit surprising. He stays in the same line, and he says that he did not know Sajan Mura. He came to know about accused Sajan Mura after seeing him on the day of occurrence. But he says, he went on saying that accused used to make quarrel and torture on the deceased. How far it can be relied that Lordship has to examine later on, looking into other things. Now, on 19/10/2014, one Sajan Munda who worked in the tea garden called me in the night at about 9 p.m. and asked me, it happened in that, the incident occurred at 9 p.m. only. Asked me to go to the house of accused situated at so-and-so. After coming to know about the occurrence, I went to the said place and accused Sajan Munda was absconding. As for him, Lordship, the accused was absconding, but as for the brother and mother, the accused was there at the place of occurrence when they arrived. At the place of occurrence.
From where have you said that he did not know Sajan Mura?
The first line, Lordship, I have come to know about accused Sajan Mura after seeing him on the day of occurrence.
No, that may not mean this. Come to know about Sajan Mura.
I have come to know about accused Sajan Mura after seeing him on the day of occurrence.
No, see, this used to reside in the same tea estate.
Lordship?
This was married to her, make quarrel.
See, he says that I know this is Onima Mura. She used to reside in the same tea estate in which I reside. So her maternal house. Onima Mura's maternal house, he's talking about. Deceased was married to accused Sajan Mura. The accused used to make quarrel and torture on the deceased. So he stays in a different place.
No, I have come to know about.
Accused Sajan Mura.
He has come to know about. He did not say, I saw Sajan Mura for the first time.
No, he didn't say so. He says that he didn't know about Sajan Mura as a person. That's what he said. He did not know Sajan Mura as a person. He has come to know about Sajan Mura only after coming to the place of occurrence. But he said that he stays in a place where Onima Mura used to stay. So Onima Mura before marriage, she used to stay with her parents, and he resides in the same line. He states that she used to reside in the same tea estate in which I reside.
Yes.
And his victim's mother and brother says that they stay in a place called Lausanne. And his address is Select Tea Estate. It's a different spelling T estate, and here it's Lausanne. Lausanne, it will be Lausanne in SMS. So Lausanne and Stellang T estate. But he states that she used to reside in the same tea estate in which I reside, and accused used to make quarrel and torture on the deceased. From where he has stated, so nothing has been stated, or like nothing has come out from the record. And he states that when he arrived there, the accused was absconding, whereas in-laws, the other two prosecution witnesses, they have stated that the accused was there at that point of time in the place of occurrence.
If you see the format of the FIR,
Yes, sir.
the information was logged in an outpost.
Initially at outpost. sir.
Outpost, what is the address of the outpost?
Outpost was
Outpost is
Hmm.
Selang,
Talent. One second.
Selanghat.
Telanghat OP.
Selanghat. And you just come to page number 2, the address of the complainant.
It's a complaint.
Address complainant 6G.
Yes.
6G. Selang,
Seleng
Lausanne.
Lausanne Kinial. Seleng Lausanne Kinial. Anyways, Lordship, that Lordship will look into.
Yes.
The local people, after making search, found accused Sajan Mura hiding in the garden behind the house and apprehended him.
Hmm.
So when he arrived, he was absconding and he was hiding somewhere
Hmm.
behind his house in a tea garden, and he was apprehended by the local police. Accused was thereafter roped in his house by the local people. After making query, accused admitted that he had committed murder of his wife Anima Mura. Accused also told that he had killed his wife by punching and assaulting on her head, left forehead. I had also noticed some marks on the neck of the deceased. So he saw another injury on the neck. On the next morning at about 6 a.m., police came and arrested accused Sajan Mura. Yeah, cross-examination part, Lord, say on the others, the next page. I have never visited Sajan Mura's house before the occurrence. I had heard about quarrel and torture made by accused of on deceased wife from local people. So what he was making a statement was a hearsay statement. He says that he had heard about. It is not a fact that I have stated falsely that accused Sajan Mura used to quarrel and assault his wife. I did not state before to the police that accused Sajan Mura used to
No, he
assault.
never said that he had seen the assault.
He hasn't. He
What
hasn't.
he had seen.
But he said that he accused used to make quarrel and torture on the deceased. The very specific statement he has made. Whereas in the cross-examination, he says, I heard from somebody else. And he in the cross-examination, he states that I did not state to the police. I did not state to the police that accused Sajan Mura used to assault his wife, since police did not ask me about the same. I did not state police that on 2014 at about 9 p.m. Sajan Munda had called me and asked me to go to the house of the accused and said that one person had killed his wife. It is not a fact that I did not state to the police that accused Sajan Mura was hiding in a garden behind his house and the local people apprehended him from the said garden. It is not a fact that I did not state to the police that accused Sajan Mura on query by local people had admitted that he had killed his wife by assaulting her and punching her on her head. It is not a fact that I did not state to the police that I had noticed mark on the neck of deceased Animamura. After going to the house of the accused, I had found 15-20 persons present in the house of the accused. I had also found accused parents present in the house, but I could not identify other persons. The house of accused was a kacha house having 3-4 rooms. I found deceased Animamura on left side room after entering into the page 19, Your Lordship, the examination of the doctor who has done the post-mortem. His name is Nitu Kumar Gogoi, Assistant Professor, Department of Forensic Medicine, Jorhat Medical College Hospital, Jorhat. On 2010-2014, I was working as Assistant Professor, Department of Forensic Medicine at GMCH, Jorhat. On that day, one body of Onima Mura, female, 19 years, wife of Sergeant Mura, village Rongkham Tea Estate, line number 12, PST of Jorhat, was brought to the hospital in connection with Selanghat OP DD number 360, dated 2010-2014. The dead body was brought and identified by one Dipok Borpatra Guhai and Manik Topna, father of the deceased. I performed post-mortem examination on the dead body on the same day and found the following. External appearance: a female dead body, thin build, swarthy complexion, wearing a green blouse, blue sari, green petticoat, eyes and mouth closed, body cold on touch, rigor mortis present. Parorbital tissues around the right eye were contused. On dissection, hammer is found inside the tissues and red in color. So injury is on the right eye. And periorbital tissues around the right eye were contused. 2. Abraded contusion of size so and so, 3 cm to 2.5 cm over right molar eminence. On dissection, hammer is found inside the tissues and red in color. Contusion of size 5 cm to 6 cm over the vertex of the scalp. On dissection, clotted blood found in the layers of scalp and red in color. So there was an injury on the scalp also. But as per the statements of the deposition of the PW 1 and 2, they did not see anything on the scalp. They only stated that injury on the left side of her eye. And PW 5 stated that left forehead. Now, Lordship, this other injuries are cranium, these are normal. Nothing is there. Abdomen, Lordship, may serial number 4, page 20. Walls healthy, this is fine. Stomach and its contents healthy, contain fluidy matter without any characteristic smell. And other things are healthy, lots of nothing is there. Then opinion as to the cause of death. In my opinion, death of the disease was due to coma as a result of head injury. All injuries are ante-mortem caused by blunt weapon. Very specific statement, Lord. All injuries are ante-mortem caused by blunt weapon, which was homicidal in nature. Approximate time since death 80 to 24 hours. Cross-examination by defense, the disease was not pregnant at the time of her death. So she was stated to be pregnant by
3 months.
the mother and the brother,
Hmm.
but she was not pregnant. And thing is that Viscara was not examined, probably because like that opinion was that because of the death due to the hit by blunt weapon. So what was the level? I mean, fluid. There was the contained fluidy matter without any restrictive smell was there, but it was not examined. What kind of fluid was there? Probably, I don't know, let's say, but they may have thought may not be important. It was not examined. Now, PW 7, Lordship, at page 22, his name is Sajan Munda, which has been referred by this other PW 5. So his residence is also at Selanghat Tea Estate. So these two people, Lordship, PW 5 and PW 7, both of them are basically neighbors of the victim. They are from the same place, same locality. So whether so in that, why I'm saying so, Lordship, that gives some kind of doubt about their truthfulness of their depositions because they are from the same place, whether they'll be interested with it. I know accused Sajan Mura. He is a resident of my neighboring village, Rongkham Tea Estate, line number 12. I used to work as night guard in an office situated near house of the accused. I also know deceased Panima Mura. She was wife of accused Sajan Mura. Distance between my office and the house of accused Sajan Mura was about 200 meters. At the time of occurrence, I was present in the office and doing my duty as night guard. At about 9 p.m. on the day of occurrence, brother of the deceased, namely Lalit Nanda Singh, came to my office and told that accused Sajan Mura had killed his sister Anima Mura. So this Lalit Nanda Singh, he actually accompanied, as per the versions of PW1 and PW2, he accompanied them to the place of occurrence. And he is one of the brother of the victim. He went there, then after that he went to this place, supposedly went to this place, this Sajan Munda's place, and informed him. And this Lalit Nanda Singh was not examined by the prosecutor. I then accompanied him to the house of the accused. I had also called two of my associates, namely Prakash Vaishnav and Joy Prakash Rajak. Joy Prakash Rajak is PW5. For accompanying us to the house of the accused. So he has supposedly intimated this Prakash Vaishnav. He's also one of the prosecution witness, and Joy Prakash Rajak. And all went there. After going to the house of the accused, we found 20 to 25 local people present in the house of the accused. Lalit Nanda Singh had shown the dead body of his deceased sister, which was lying on the bed inside the room. The local people gathered told us that accused had killed the deceased by punching and assaulting her. We also found the accused present in the house. Lordship, may kindly note this. We also found the accused present in the house, and he stated that he had assaulted and punched the deceased on her head. But whereas PW5 said that the accused was absconding, and local people only told him that the accused assaulted the victim by punching. But both these people were there and they went together. Maybe in a, I mean, he was informed little bit later on, maybe, but they were there at the place of occurrence. But he has stated that like, we found 25 people. So he means that all these three. We also found accused present in the house, and he stated that he had assaulted and punched the deceased on her head. I then contacted the police and informed about the occurrence. Having seen the same, accused wanted to flee from the place. So it's a totally different version. As per him, Lordship, after he has intimated the police, then he wanted to flee. Till that point of time, accused was there. We then apprehended him and kept him roped in his house until arrival of police. So going to, going behind the house, hiding in the tea garden, and bringing him from there, then roped in as stated by the PW4, PW5, and his statement as PW7 is contradicted. On the next morning, police came and arrested the accused. I had seen injury mark on the right forehead of deceased Onimamura. So he says about right forehead, and like other PW1 and 2 says about left side of the eye. It's not exactly telling. Cross-examination by the defense also. I did not say to the police that Lalit Nanda Singh had come to my office at about 9 p.m. on that day of occurrence and informed me that accused Sajan Mura had killed his sister Onima Mura. We had apprehended the accused from the adjoining garden of his house when he tried to flee from the place after knowing about police. So he again gives a different kind of a question. I had seen the injury on the right forehead of Onima Mura above her eyes. One line, Lordship, it's important that like on the next morning, police came and arrested the accused. So PW7 said on the next morning, police came and arrested the accused. PW5 also stated the same thing. On the next morning, about 6 a.m., police came and arrested the accused Sajan Mura. Now, page 24. Look. His PW8, his Prakash Vaishnav, he's also referred by PW7 in his statement. He also accompanied them to the place of occurrence. I know both accused Sajan Mura and deceased Anima Mura. Accused Sajan Mura had married Anima Mura and used to reside at Rangkham Tea Estate, in which I reside. The occurrence had taken place in the month of October 2014. This person, Lordship, this Vaishnav, Prakash Vaishnav, he used to stay in the same place where this accused used to stay. the Rongkham Tea Estate in which I reside. He was not staying in the place where the victim used to stay, or the other PW5 and PW7. They were from PW5, PW7, and the victim and the parents, they are from the same locality. And this is a different locality where the accused used to stay. And here, this person is to reside in the same Rongkham Tea Estate. The occurrence had taken place in the month of October 2014. On the night of occurrence at about 9 p.m., Sajan Munda, PW7, informed me over telephone that accused Sajan Munda had killed his wife Anima Mura. At that time, I was present in my house. After getting the said information from Sajan Munda, I went to the house of the accused and found Anima Mura lying dead on a bed. Sajan Munda had informed police that accused Sajan Munda had killed. Sajan Munda had informed police that accused Sajan Munda had killed his wife. About 20-25 local people were present in the house of the accused. Police has instructed Sajan Munda to keep the accused apprehended till their arrival. Local people apprehended accused since the accused had wanted to flee to the garden adjoining to his house. Police came on the next morning and arrested the accused. I had also joined local people in apprehending the accused. I had noticed injury near the eye of the deceased Anima Mura. The injury is near the eye only. PW1, PW2, PW8 stated that injury is near the eye of the deceased. But nothing has been mentioned about the scalp, head. Nothing has been mentioned. But PW5 and PW7 has stated that forehead. The cross-examination part is at page 25, Lord Chief. It is not a fact that I did not state to the police that Sajan Munda had informed me over telephone on the night of occurrence that accused Sajan Munda had killed his wife. It is not a fact that I did not state to the police that accused tried to flee to the adjoining garden of his house, and I, along with local people, had apprehended him. It is not a fact that I did not go to the house of the accused on the night of the occurrence, and I had only accompanied Joyprakash Rajak to the police station. It is not a fact that I have deposed falsely today without going to the place of occurrence and without seeing the body of the deceased. PW10 is at page 26, Lordship. It's Bijoy Dandasi. So he also is from the same locality of Chalang Tea Estate where the victim used to stay before marriage. I know accused Sajan Mura. He married one girl named Anima Mura who is
Just a minute. PW9 may not be relevant.
Yeah. The only thing is that he's also from the same place, and he
There's no relevance.
He did not say
Except-
anything about
Except
any,
the death of the deceased in the matrimonial house.
correct. And he didn't say about any quarrel or any kind of issues earlier. He didn't say anything about. The PW 10 will be very important, Lordship. His name is Muhammad Samsuddin. So he,
Ayo.
Ayo. May I read it?
Yes.
On 2010-2014, I was posted at Selanghat outpost as in charge of police. On that day, in the morning at 6 a.m., one Prakash Vaishnav,
Yes.
Sergeant Munda, Uttam Dandasi appeared at the outpost and informed that Sergeant Mura, son of Manik Mura of Longtham Tea Estate, had killed his wife Anima Mura. So, Lordship, the statement about calling and telephoning and intimating on the previous night, as well as keep that police had asked them to keep him in the house only. It really goes. The said three persons had also brought accused Sergeant Mura. So what they have stated earlier, the police came and the police arrested. And they have kept the accused in the house, rope. But he states that these three people came in the morning and brought this Sergeant Mura along with them. The said three persons had also brought accused Sergeant Mura. Very clear statement, Lord. After entering the said information in the GD, right, so and so, I went to the place of occurrence. So he went to the place of occurrence after making the GD entry when these three people went along with the accused to the police station. The accused was assaulted by public. And as such, after forwarding him for treatment to hospital, I moved towards the place of occurrence. The accused had already been assaulted. So this will be important because Lordship, this extrajudicial confession and all these things will come. Exhibit 3 is the extract copy of the said GD entry which is available in the case diary. After reaching the place of occurrence, that is the house of the accused, which is situated at Longtham Tea Estate, I found deceased Anima Mura lying dead inside the house. I also recorded the statement of witnesses. I also prepared a rough sketch map of the place of occurrence. Exhibit 4 is the said rough sketch map of the place of occurrence prepared by me. Exhibit 4 is my signature. I also forwarded the dead body of Anima Mura to GMCH, Jorhat, for post-mortem examination. Before forwarding the dead body of Anima Mura for post-mortem examination, inquest over the dead body was conducted by ADM Duzen Singh. This ADM Duzen Singh was never examined. Exhibit 1 is the inquest report prepared by ADM. Exhibit 1-2 is the signature of ADM Duzen Singh, which I know. After returning from the place of occurrence, I received an FIR by Lolit Dandasi. Exhibit 5 is the said FIR. Exhibit 5-1 is my signature. After receiving the said FIR, I made entry in the GD and forwarded the same to OC PIOC PS for registration of a case, and PIOC PS case number 32414 under section 302 IPC was registered at PIOC police station. After registration of the case, OC PIOC police station had entrusted the said case to me for making investigation. I have also interrogated the informant complainant at police station. After recording the statement of the complainant, I have interrogated the accused and having found sufficient incriminating evidence against him, I arrested him. Accused Sergeant Mura had admitted his guilt before me and stated that he had killed his wife by assaulting her with his hand. I also collected post-mortem report of deceased Onima Mura from GMCH Jorhat, and after completion of investigation, I submitted charge sheet against accused Sergeant Mura under section 302 IPC. Exhibit 6 is the said charge sheet filed by me. Exhibit 6.1 is my signature. Manik Tapan Mura, in his statement under section 161 CRPC, has stated before me that since earlier his son Sergeant Mura used to beat his wife Onima Mura. PW4 further stated before me that on the previous night of occurrence, after coming home, he found his daughter-in-law Onima Mura in a critical condition, and thereafter, due to continuous assault by his son, she died. PW4 further stated before me that after coming to know about the death of Onima Mura, when her family members came and tried to apprehend accused, he fled away. Cross-examination part, Lordship. I reached the place of occurrence in the morning at about 7 a.m. Jayaprakash Rajak did not state before me that accused Sergeant Mura was hiding behind his house, and local people apprehended him from the said garden. PW5 also did not say before me that accused Sergeant Mura, on query by local people, admitted that he had killed and punched his wife on her head. This is also important, Lordship. He did not state before me that he had noticed mark on the neck of the deceased Onima Mura. PW5 admitted that the accused had killed his wife by assaulting her and punching her on the head. This, Lordship, I could not understand. PW5 admitted that he had killed his wife by assaulting her, punching her on her head. This, Lordship, I could not understand what exactly he meant.
No.
PW5 is
admitted that
Hmm.
he, we didn't make it
accused had killed his wife by assaulting her.
That means PW5 had said that
Maybe,
the accused had,
maybe.
not recorded in the correct.
Maybe. Prakash Vaishnav, PW8, did not state before me that Sergeant Munda had informed him over telephone on the night of occurrence that accused Sergeant Munda had killed his wife. PW8 also did not state to me that local people had accompanied him while apprehending accused from their adjoining garden of his house. It is not a fact that investigation. So this PW statement of PW5, PW7, PW5 and 8, in fact, Lordship, that he was hiding behind the house in the garden. He has denied that, like that has been stated before the police. They haven't stated before stated this before the police. They have stated for the first time while depositing on it in their deposition. It is not a fact that the investigation conducted by me was perfunctorily, and I filed the receipt against the accused without any basis. Page 30, Lordship, 313 statements of the accused.
PW4 was the father of the
Yes, sir.
accused
Yes.
who had not.
He
hostile.
was declared hostile. The first statement, Lordship, PW1 in his evidence stated that after getting information about the serious condition of his sister Onima Mura, he went to her maternal house along with his mother and brother, and found it. So he states that yes, he came to our house after occurrence along with his mother and sister. Lalit Dandas, then question number 2, Lalit Dandas, CPW1, in his evidence also stated that on being asked about the occurrence, you had told him that you had beaten your deceased wife Anima and then given medicine. Is it correct? It is totally false. I never said so to PW1. So basically, he states that like, he never actually had beaten her. Then, Lordship, question number 3. This is regarding that pregnancy thing, Lordship. I mean, both PW1 and PW2 saw at that time the disease was pregnancy of 3 months. It is false. She was having her period at that time. Question number 4 also, Lordship, he denied that I never beaten my wife Anima Mura. Then question number 5, Lord.
Yes.
PW2 Malati Dandasi in her evidence also stated that her daughter had died due to physical assault made by you. Is it correct? What do you say? It is totally false. I never assaulted PW2's daughter. She had consumed poison and died by falling inside the house.
But the aspect of poison was not detected in the PM.
PM Lordship, that as I pointed out, there was some liquid. There was some liquid
there-
there,
there
but
was-
it was not tested. I mean, it was not sent for any testing.
But there was no pungent or any foul smell.
Yes, the characteristic smell was not there. That was written in the PM. But like there was presence of fluid that has been mentioned specifically, but that was never sent for any test.
But what the ultimate opinion that the injuries found on the head, which appears
Yeah,
to have
correct,
been caused by blunt weapon,
Correct.
was sufficient to cause the death.
That's correct, Lordship. I mean, it seems like they didn't suspect anything.
Anything else?
They didn't suspect anything, but presence of fluid was there, and this was not sent for testing. That is coming from the record. And he has taken a plea now that he has consumed poison. Then question number,
What was the cross-examination put to the doctor?
as far as this, Lordship, nothing has been.
Only the pregnancy part.
Yes,
Only the pregnancy part.
only that. Disease person was not pregnant at that. It was not
No suggestion. even.
nothing was put, no suggestion was there. Then then question number 7, 8, Lordship, he denies it that he had assaulted his wife. And question number 9, he states that my wife had fallen on the ground and as such sustained injury. As far as injury is concerned, he has stated that he had fallen on the ground and got injured. That may be the reason of her death. Page 32, Lordship, question number 12, Lordship, may kindly have a look into this. PW7, PW5 and 7, actually, Lordship, they are implicating him as far as their statements are concerned. So 7, what as far as
Question number?
12, the PW7 Sergeant Munda in his evidence also stated at that time, at that time, you had told them that you had assaulted and punched your deceased wife Anima. He further stated that when he contacted police, you then tried to flee away from the PO. Is it correct? What do you say? It is totally false. I never tried to flee from my house and also never apprehended me by any of the villagers. So this is his statement, and like I think police has also stated that and nothing has been stated about this.
But police IO has stated that
He was handed,
was-
he
he
was
was handed
taken
over.
to, he was taken to the police station.
so apprehension was by the public was there, that aspect.
That aspect has
Okay,
to be
we'll
looked
come
at.
back at 2 o'clock.
Sure.
We may not have chance to do any other matter because 2:45 this bench has to rise. And we have to hear DPF.
Next week in a day, my lord.
Oh, yes, we'll give matter dates. We'll give it. I'll work it.
So Lordship, we will page 32, T1 page statement. Question number 14. I'll just read his answers because it's not very relevant. So about his absconding and all, I never tried to flee away. Because there are some conflicting things about his, whether he absconded, because that gives the veracity and like truthfulness of the statements made by the witnesses. So that was the thing why absconding thing becomes very important, whether he tried to flee or whether he was there. So there were some conflicting statements on that. Page 33, Lordship, that question that do you have anything to say? So he explains his, position. I'm totally innocent. My wife died falling inside the house. She had consumed poison when I was not present in the house. When I had gone for work, I told her not to take any sour, or she was she was having period, and to take medicines as she was anemic and weak. After I returned from work, my mother said that she had fallen. My wife had also said to me that she had consumed poison. My wife was very weak. Apart from me and my wife, there was my mother, 2 sisters, and elder brother. So all these people also, we were present at that point of time, and like it seems the mother told him that like she had fallen, so nobody was examined by the police. Those people are present at that point of time when this incident happened, but no one was examined. It really goes to the root of the matter also, because people were present there, nobody was examined. The boy who was informed PW 1 and 2, he was not examined. The brother who supposedly accompanied them to the place of occurrence, he was not examined. The only 2 witnesses they have relied. Those 2 witnesses were basically from the same village where this victim used to stay, and they have only stated that they had a quarrel. And as far as the quarrel thing, also like aspect of quarrel, as that earlier days to have quarrel, and only PW 5 is stated about this. So motive part, Lordship has to examine whether there was any motive to kill the wife. But from the record, Lordship, there was no motive. No motive is coming out. No, and PW 1 and PW 2 did not say anything about the quarrel. Only PW 5 had stated that there was they used to quarrel between themselves. There was some quarrel between them. Nobody else has stated anything. Now, Lordship, I'll take Lordship directly to the inquest report. Inquest report is at page 63. Inquest was done on the next day only, 8:30 a.m., page 63. I'll take your Lordship to page 64, description of dead body. The build, Lordship, is fine. Complexion, okay. Identification mark, nil. Deformities, Lordship will say. Deformities. Injuries mark on her page 64, Lordship. Serial number 9.
Yes.
Description of the dead body. The deformities part, Lordship, may kindly see. Injured mark on her right cheek near eye. No other injury was mentioned. No other injury was mentioned. Teeth is fine. Eyes, burn mark, nil.
No,
more.
inquest is not a
Not-
descriptive
not-
narration.
Yeah, yes, correct.
What
but-
appears out from the outside, because
Yes.
teeth, eyes closed, she will not be able to say about the teeth.
But as far as Lordship, the injury in the head, injury in the forehead, injuries in the scalp, that will be definitely, they would be able to identify that. If that is so grievous and only because of that somebody died. That should have been there on record. Lordship will find at page 65, description of injuries found on the dead body. Serial number 10, head injury, Lordship will find nil. On the top, Lordship. Head nil. Face injured mark on her right cheek near eye. Only that one. Other things are Lordship, I don't think that those are relevant. Only thing I just wanted to point out, Lordship, that injury part, which has been stated about the head injury on the scalp and the forehead, nothing has come out from here. Head, it's nil. Only injured mark which has been seen and identified at that point of time is that right cheek near eye. And there was a mention, PW5 mentioned that there was injury in the neck also. Nothing has come out from here also. There is nothing has come out from the post-mortem report also. I will point out to your Lordship. 66, Lordship will find, page 66. Opinion of witnesses, serial number 12. Opinion of witnesses and police about the case of death and weapons or instrument used thereof, if any. Cause of death due to assault by her husband by hand, and dead body sent to PM for PM examination to ascertain the actual cause of that part. So apparently, let's say when the inquest was done, so there was no injury on the head. It says nil. Now let's see, we'll see the post-mortem. It is at page 68. It starts from page 68. It was done on the same date, 2010-2014. Page 69, Lordship will find the external appearance. Serial number 2, wounds, position and character. Injuries, Lordship will find that I have already read out, but for PM report, I'm reading it out again. Periorbital tissues around the right eye are confused. On dissection, hemorrhages found inside the tissues and red in color. Abrated contusion of size 3 cm and 2.5 cm over the right molar eminence. On dissection, hemorrhages found inside the tissues and red in color. Then 3, contusion of size 5 cm into 6 cm over the vertex of the scalp. On dissection, clotted blood found in the layers of scalp and red in color. So that post-mortem report says. Then page 70, Lordship will find cranium and spinal canal. Number 2, skull vertebrae, skull as described, skull healthy, vertebrae healthy. Vertebrae healthy. Then Lordship will find membrane congested, diffuse subdural hemorrhage present over the brain, and brain and spinal cord, brain congested. Page 71, Lordship will find stomach and its contents healthy, certain fluidy matter without any characteristic odor. Small intestine also is a healthy, contain fluidy matter. This fluidy matter was not examined. The opinion of Assistant Surgeon, Lordship will find at page 73. Death was due to coma as a result of head injury. All injuries were antemortem caused by blunt weapon, which was homicidal in nature. So this blunt weapon was never recovered. It specifically says about blunt weapon. It doesn't opine that somebody who has been beaten by hand and by a punch, he was killed.
How will you distinguish between being assaulted by a blunt weapon and by a fist?
A blunt weapon means like somebody has to be very strong. Somebody has to be very strong and very thick, and something is very hard material. But somebody's fist is not that kind of a. I mean, it can't be said as a weapon.
No,
It's,
no.
it's a special
No, the expression used is weapon. We understand.
weapon. So weapon.
How will you distinguish between an injury caused by a fist or by a kick? It is not a slap injury.
It's not a slap injury. I mean, there's a
It can be a
statement that
kick.
it has been punched or something
Just,
like that.
for the sake of argument, suppose a kick has been given or a blow by the fist, and an injury is caused which leads to death. So how can you differentiate between the
Usually, Lordship, it's a, I mean, as per the prosecution story, it's a grievous injury. Grievous injury which actually led to the death. Now, thing is that like that PM report says a blunt weapon. The weapon we all can well imagine that like a weapon, if it is hurt, if that is used for hitting somebody on the scalp, obviously Lordship, somebody may die. But like as far as Lordship, and when a hard material like weapon that is used to hit somebody, then what happens that tissues and all, surrounding tissues and all, they get scattered, and like they are scattered, and like the tissues will be totally displaced. But like as far as like fist is concerned, like I don't think like the fist will cause that much of a damage to somebody's. So that there is no opinion as such from in the PM report that a fist can also cause that kind of a injury and that can lead to death. No opinion has come like this. It has specifically stated that blunt weapon, and that weapon was never recovered. So, Lordship, there is, I mean, as far as the prosecution story is concerned, the death caused by death was due to use of some weapon. Then the weapon could have been discovered. There was no effort to discover, effort made by the prosecution to discover that weapon because PM report was available with them. Also, as far as the judgment and order and conviction is concerned, also the learned trial court judge has basically relied on three aspects. Okay. One is that circumstantial evidence. He says that like chain is complete. There is the guilt is very apparent from the circumstantial evidences. And for this, Lordship, he has relied upon extrajudicial confession and the statements of this PW, basically the PW5, PW7, and PW8. I'll just take your Lordship to a couple of paragraphs from in this. There are 45, I'll just read out very quickly, Lordship, page 54. How he has come to the conclusion, Lordship, I'll just point it out. Is para 45, applying the above principle as said by the Honorable Apex Court in the above mentioned judgment to the facts and circumstances of the instance case, Anima Dandasi died an unnatural death in her bedroom, which is also occupied by the accused person as her husband. Apart from the accused person, mother of the accused and his two sisters, along with elder brother, lives along with him. But these people are not examined, Lordship. but there is no any allegation against any other family members of the accused person, and all the prosecution witnesses deposed that it was accused person who had assaulted the victim by punching her face and head. This is not correct, Lord. So, I mean, as far as punching her face and head, it was not there, not there in the statements. Only wife has stated that like it was some punching was done, and he said, in fact, servant has stated that he has heard from somebody else that there was some beating. Punching her face and head due to the impact of the assault, deceased died. So when the deceased died inside the residence of the accused person, it was the accused person who has the knowledge regarding the cause of his wife's death. But it appears the accused person has not properly examined on what circumstances and how his wife sustained grievous injury on her head. And in the circumstances, section 106 of the Evidence Act is applicable against the accused person to prove the circumstances within which is within his knowledge. Lordship, there is an explanation he has made that there was she had fallen there. The explanation he has already made that he was not there when he came there. Then he found that like he has fallen and like there was an injury in the head. So he has in fact, Lordship, like I mean, as far as section 106 this thing condition is concerned, he has already complied with. He has stated that there is some injury because she had fallen, and now the prosecution should have proved it. In case resting on circumstantial evidence, if the accused person failed to offer a reasonable explanation in the charges of burden placed on him, and that itself provides an additional link in the sign of circumstances proof against him. In the instance case also, the accused person at the time of recording his evidence under section 313 CRPC, on one side took the plea that his wife consumed poison. On the other hand, he again took the plea that at the time of occurrence, he was not present in his residence. But he stated, Lordship, that he has came there and he asked his wife, then his wife has said that she consumed poison.
Where is that?
That is there in his 313 statement, Your Lordship.
Question number 16, the answer
Yes,
is that she had consumed poison and when he was not present in the house.
correct.
Then when did he return home? He thereafter claims that wife had said to him that she had consumed poison.
Yes.
But what did he do if she was?
So,
in-
so the learned trial court.
No. See, as a reasonable person, you come back, you find that the wife is in a feeble state. She narrates that she has consumed poison. She has also fallen down and got injured. What is your reaction? What did you do?
But Lordship, at that point of time, when he probably, Lordship, when he, I mean, there was no time to do anything because he already died
No.
after some time.
No. Did you try to send her to the hospital or call a doctor or what is
So that was not there on record. But there's nothing, that's sort of the material on record. Lordship. And nothing has come in the cross-examination part also, Lordship. Nothing was there. The only thing was the explanation was that she was pretty weak at that point of time, and when he came, that like she told that the victim told that she consumed poison, and she had fallen, and because of that, the victim died. But Lordship, this statement, at least the conclusion part, that in the instant case also, on one side took the plea that his wife consumed poison. This is already there. He has stated. On the other hand, again, he took the plea that at that point of occurrence, he was not present in his residence. There is no conflict in this, Lordship. There was no inconsistency in that. He said that when he came, he asked his wife, then she said that she consumed poison. I haven't taken any plea, made any contradictory statement as far as this is concerned. As I discussed earlier, said plea was not taken by the defense side while cross-examining and the prosecution witnesses, and hence, in my opinion, the apposite explanation given by the accused person at the time of recording his statement under section 313 is not a believable. That is the conclusion the learned trial court has drawn. Now, also, next paragraph is important. In the instant case, another circumstance which goes against the accused person is that accused person has made extrajudicial confession in front of neighboring people who had gathered at the place of occurrence after the death of victim. How come it has, how it has come out? None of these neighboring people has been examined. Nobody has been examined. How come he has come to this conclusion that he has made accused person has made extrajudicial confession in front of the neighboring people who had gathered at the place of occurrence after the death of the victim? No doubt extrajudicial confession is a very big
No,
piece.
the PW5 has said.
PW5 has stated, Lordship, that is again,
At
Lordship,
page 17.
yes, that is again a contradictory statement, because I will not say exactly as contradictory
No,
statement, but that has been
contradiction has been denied. At page 18, contradiction was put to him. He has denied it.
yes, Lordship. But no, what I'm saying is that page, what
to page
PW5 has stated and 7 has stated, they're different stories. Lordship will find page
Come to page 17.
Page 17, Lordship will find the local people, the accused Sajan Mura was absconding in the middle part, Lordship.
Yes.
The local people, after making search, found accused Sajan Mura hiding in the garden behind his house and apprehended him. Accused was thereafter roped in house by the local people. After making query, accused admitted that he had committed the murder of his wife Onima Mura. That is his statement, Lordship.
No,
Now, accused also told that he had killed his wife by punching and assaulting her on her head.
Direct statement.
Correct, Lordship. That is there. Then, Lordship will see page 22. Page 22, Lordship will see page PW7. Towards the bottom part, Lordship, local people gathered there told us. Local people gathered there told us that accused had killed the deceased by punching and assaulting her. So this becomes a hearsay again.
No, so we are not on PW7.
No, that I understood, Lord. So PW5 has stated that this has been stated to him. But as per the prosecution story, Lord, these 3 people were together. One person is saying that PW5 has stated he was absconding, then he was brought back from the tea garden. Then he said that, like, I have punched and
you see, thereafter you see, read the next line. Please read the next line.
Next line also, we
also found
the accused present in the house.
And he stated
That he assaulted and punched the deceased on her head. I then contacted the police and informed the police about the
so there is
occurrence.
no inconsistency of PW7 and 5.
PW5 and PW7, yes, Lordship,
There is no
certainly.
inconsistency.
Uh,
Because 7 also stated that local people said, then he also stated.
But here, Lordship, well, the other people were not examined. Here, this, while coming to the conclusion, learned trial judge stated extrajudicial confession in front of the neighboring people who had gathered at the place of occurrence after the death of the victim. Other than PW5 and 7, nobody was examined.
This cannot be perverse. See, there are materials to come to that conclusion.
Now, Lordship, may kindly come to page 58. I'll just point out one more paragraph. In the instant case, PW5 and paragraph 49 here. Page 58. In the instant case, PW5, PW7 and PW8 are independent witnesses. And while they had arrived in the residence of the accused person on the date of occurrence, the accused person confessed before them that he had assaulted his wife by giving fist blow on her face and head. So here PW 5 and 7 lordship can take it because they have made statement. PW 8 has not stated something like that. And other neighboring people were not examined. And PW 7 and PW 8, though has been mentioned as independent witnesses, these two people were actually the neighbors of the victim before her marriage. So basically, lordship, the whole case is based on this PW 5 and PW 7 mostly. And PW 5 and 7, lordship, as far as absconding party is concerned, as far as information is concerned, there are certain doubts. There are certain doubts. And PW 8 hasn't stated like that. And lordship, as far as the extrajudicial confession is concerned, lordship has already seen, I have pointed out, that there was an assault. So how far this extrajudicial confession can be taken into account for convicting?
Where is that assault part?
Assault part, lordship will find that PW 6, PW 10, lordship. PW 10 Samsuddin.
Ayu.
Ayo. On 20, this is a page 27 here. On 2010-2014, I was posted at Chalengkat outpost. On that day in the morning, 6 a.m., one Prakash Vaishnav.
You're reading page?
Page 27 here, Lordship.
27.
And what made him to lie, Lordship? That
What is it? 27?
Yeah, 27, Lordship.
27, yes.
27, page 27. On 2010-2014, I was posted at Chalengkat outpost as in charge. On that day in the morning, 6 a.m., one Prakash Vaishnav, one Sajan Munda and Uttam Dandasi appeared at the outpost and informed that Sajan Mura, son of Manik Mura of so-and-so, killed his wife Anima Mura. So whereas Sajan Munda has stated that he has called, Prakash Vaishnav said he has called the police over the phone at that point of time only. I mean that is the previous night. They have incident happened that day only they have called. But here this IO has specifically stated that they have gone to the police outpost. The said three persons had also brought accused Sajan Mura. So picking this accused from the place of occurrence is totally false. What story that PW 5 and 7 has narrated is totally false. If IO has, the prosecution has stated so. The said three persons has brought accused Sajan Mura. After entering the said information in the GD, I went to the place of occurrence. The accused was assaulted by public. As such, after forwarding him for treatment to hospital, I moved towards the place of occurrence. So there's a clear-cut statement stating that there was an assault by the mob. When there was an assault on a person, at that point of time, if he makes some kind of a statement, whether that can be taken into account to convict a person. So again, Lordship, if we go to page 59, so he has cited, learned trial court has cited a couple of judgments, and he has come to a conclusion. The conclusion part is page 52, paragraph 52, page 59. Hence, in my considered opinion, when there is ample evidence regarding the involvement of the accused of committing the murder of his wife the motive loses its importance, and even prosecution side failed to prove the motive in details regarding committing of murder of wife of the accused. That will not affect the whole prosecution case. So as per him, Lordship, as per him, the circumstantial evidence is sufficient. The whole chain, the whole circle has been totally made up. It has been filled. And there is no doubt of any guilt of this accused. So here, Lordship, as I have pointed out, Lordship, the first thing is that extrajudicial confession, which he has relied on, that cannot be relied on as per law. I'll come with some case laws on this. That he was assaulted by a mob at that point of time. In that kind of state of mind, he has made some statements that cannot be taken into account to convict him. Secondly, circumstantial evidence, Lordship has seen, Lordship, as far as only statements of PW 5 and 7, mostly. On the basis of that, conviction has been made. And PW 5 and 7, Lordship has seen, as far as story is concerned, that absconding part, that he was there, he has been taken by the people, local people, to be taken back home. Then he was, picked up by police. This is a totally false story, Lordship. In fact, they have informed the police on the next day, and they went themselves to the police station along with the accused. An accused was handed over. An accused was sent to the medical examination. So this story is, Lordship, totally doubtful. It creates a lot of a doubt here, Lord. And considering all these aspects from the evidence on record, the prosecution witnesses coupled with circumstances as discussed above, in my considered opinion, all the circumstances have a definite tendency pointing the guilt towards the accused, and in their totality, unerringly lead to the conclusion the accused, namely Sergeant Mura, and none else has committed the crime. So that is his conclusion. So in my humble submission, Lordship, this circumstance in case of there was no eyewitness. In case of circumstantial evidences, that guilt has to be really, it should not have any kind of doubt at all. Here, Lordship, prosecution has failed to examine very important witnesses, couple of important witnesses. First one is that boy who was the first person, Lordship, first person who has in fact told other people about the incident, happening of the incident. He was the first person who has intimated. So he must have had the first knowledge that that person was not there. Then another person, Lordship, who is the brother of the victim, who also accompanied the mother and the informant to the place of occurrence, and who has supposedly gone to the place of PW5 also and intimated him about the incident. He was also not exact. Very important witness, not exact. Then while the incident took place, at that point of time, there are a lot of people in the house. The mother-in-law was there, father-in-law was there, there were sister-in-law, nobody was examined except the father. The father was declared the hostel leave. So in view of this, and
Father-in-law was examined.
That's what was. The father-in-law was examined, he was declared hostel leave. He was the only person who was examined, and he stated that there was a kind of poison. There was no assault. Of course, he was declared hostile. Now, Lordship, in these circumstances, Lordship, in this fact and circumstances, whether the conviction is really required, that has to be looked into by your Lordship. Circumstantial evidence is Lordship, that has to be really proved beyond doubt, to the full certainty. It cannot leave any kind of doubt. Extrajudicial confession, Lordship, as Lordship is aware, this is a very weak kind of evidence. So that has to be seen, that has to be really measured, how it has been made, to whom it has been made, at what circumstances it has been made. Those things has to be measured, And Lordship, inquest report and PM report, there were some gaps. Inquest report, there was no mention about any head injury. There was no mention about any other injury than this injury on the in the on the right hand side of the eye. But as per the postmortem report, it's a very grievous injury, injury on the scalp, injury in the forehead, and blunt weapon has been used. Blunt weapon was not recovered. There was no effort from the prosecution to recover the blunt weapon. If whether there was any weapon used, nothing has been. So, Lordship, as far as circumstantial evidence and extrajudicial confession, there is a case law, Lordship, I would like to rely on. It's a very recent case which has been decided by the Supreme Court. 2025 PSCC 565.
Yes.
And Lordship, another thing, Lordship, that motive part, Lordship, motive part is totally missing. Only one statement has come from PW5 that there was some quarrel. At the same time, he doesn't stay there also. He doesn't stay in the neighborhood. He hasn't himself seen. He must have heard from somebody else, and it's a hearsay evidence. The para 19 to 26, Lord. May I read out?
Yes, please.
Extrajudicial confession of an offense made by the accused before a witness is one of the several instances of circumstantial evidence. There are other circumstances as such. The theory of last seen together, conduct of accused before or immediately after the incident, human blood being found on the clothes or a person of the accused which matches with that of the accused, leading to recovery of weapon, etc. As we know, circumstantial evidence is not direct to the point in issue, but consists of evidence of various other facts which are so closely associated with the fact in issue that taken together, they form a chain of circumstances from which the existence of principal fact can be legally inferred or presumed. The chain must be complete in each fact forming part of the chain must be proved. It has been consistently laid down by this court that where a case rests squarely on circumstantial evidence, inference of guilt can be justified only when all incriminating facts and circumstances are found to be incompatible with the innocence of the accused or guilt of any other person. The circumstances would not only have to be proved beyond reasonable doubt, those would also have to be shown to be closely connected with the principal fact sought to be inferred from those circumstances. All these circumstances should be complete, and there should be no gap left in the chain of evidence. The proved circumstances must be consistent only with the hypothesis of guilt of the accused and totally inconsistent with his innocence. The circumstances taken cumulatively must be so complete that there is no.
Will have to rise to 45. Tomorrow, how much longer will you?
I'll just refer to his case laws. I may have 2-3 case laws.
And madam? So tomorrow first hearing, you refer to the other judgment, then we'll hear madam for
First item.
first hearing. Okay. Third, Sri E. Kulita Leonard America Security, who has America Security, as well as Miss E. Begum, Leonard APP Assam, Para. The arguments of the learned amicus has remained inconclusive. Full stop. Don't say in amicus. The arguments have remained the hearing has remained inconclusive. Para. Reach list for hearing again tomorrow as part heard.
Published.
Item number 8, my lord, we have filed an additional affidavit as well as a petition for impleading of a respondent whose rights may be affected, but he has in the meantime retired. But my lord, if there is a order, my lord, where the gradation list which is under question, in regard to that gradation list, my lord has appeared as a counsel who has submitted before this court in regard to that gradation. So your lordship may not like to take up this matter because I have annexed that gradation list.
This
that
matter has been taken up by this court. Why are you making this submission at this instance? Counsel as what? For this petitioner?
I'm for
No, no, this court has appeared
your lordship has appeared as an additional advocate general
for,
for the forest department.
doesn't matter. How does it matter?
But your lordship will require this additional affidavit and the impleading petition to
When did
come
you
on
file?
today.
No, we had fixed it today for final disposal. You
My
should
lord,
have brought it.
I pray for a small
You
accommodation
should have-
for
you should have brought it.
yeah no
We had heard this matter at length on the last.
no on the
occasion.
last day I was not there. My lord.
Your colleague was there.
Yes,
There is
I
no
have to
cause
take.
of action existing. Why are
No,
you
no, madam.
persisting
No,
on
madam.
this
There is
matter?
cause of action is still
He
subsisting.
got his promotion, if you remember correctly, on
Yes,
the
yes.
last.
Yes, but it has to be retrospective from the day when I was entitled because at that time, my lord, this matter
You
was.
argue upon that, bring your additional affidavit. We'll see.
Yes, your lordship.
And why do you make this submission of recusal at this moment?
No, my lord.
After
it
this
was-
court has taken up this matter on.
No,
two,
my
three
lord. On the
occasions.
last occasion, my friend ought to
And
have.
how are you connected if you have applied for forest department? Will is any forest matter will not take you?
No.
What
We
is
will,
that?
we will argue the case on merit before any
like
court, my lord. It's, they have asked for, pointed out. I have that page 40 order is there, my lord, because it is in respect of the same, but if your lordship takes up, we will argue in merit, my
You
lord.
bring
We have no problem, my lord. We have no problem, my lord. We'll argue, man. Only for these two documents has to come on record. Or your lordship may fix it only next week, my lord. Today I have another hearing scheduled in another court. Only Monday, Tuesday, I'm not, Monday, Tuesday and Wednesday, I'm not there. On next Thursday, if your lordship.
BD for learned senior counsel for the petitioner has submitted that an additional affidavit
And then I,
and an IA for impleadment has been filed today,
yes, sir.
which however are not on records. Para, list after a week along with the aforesaid, along with the IA and additional affidavit said to have been filed today.
Any day on 15th or 16th, subject to your lordship.
One week you have said.
On the day when I'm not there, if it is then it will not look proper to take an adjournment, my lord.
We have not put a date this way. One week you have said. Bring it after a week. Yes.
Please, your lordship.
We are obliged. to.
As per text mention, item number 5 of today's report.
Yes.
1 week time may be allowed. I have to reconstruct a file for the veterinary department.
Three RR Google and standing counsel for the department is present. Yes, item number 5, what is it?
I have to reconstruct a file, accept the record, lordship. That's why 1 week time may be allowed. I have to taken the consent of
He
the other
doesn't
side.
have the instruction. It's a matter of some recruitment long back.
Yes, lordship. But
Why do,
Reconstruct the file, I
what do you need to reconstruct?
only 1 week time, lord.
Mr. Sharma, you don't have the instructions in this. Clients are not in touch. We wanted to dismiss it only because you are not present and you are seeking time. 21 matter, does it look good? 2025, you are seeking time to reconstruct the file. What were you doing last 4 years, madam?
Lordship, I am not, my was not reflected.
That is why I have got it reflected.
Lordship,
Now,
the
why
last
do you, why
occasion
do you
it is reflected.
you are seeking time to reconstruct file after 4 years? What were you doing all these 4 years?
Lordship,
He
I
doesn't have instruction. We are not even inclined to take up the matter further and you are seeking time.
only Tuesday, lordship.
We don't understand what is going on.
That's the last chance, lordship, on Tuesday.
Heard Sri MP Sharma Leonard. You know why these matters are listed before this bench? Why is this bench specially sitting? We are a part of a special DB, which are the most important matters. Persons are behind the bars. In spite of that, this bench is specially sitting only for all matters. And you are
Apologize
seeking time.
for the conflict.
Heard Sri MP Sharma. Learned counsel for the petitioners. Ms. M. Kotoki. Learned standing counsel. Animal husbandry and veterinary. Has, however, sought for time to reconstruct her file. Para. Considering that the writ petition is pending since the year 2021, this court has reluctantly granted a week's time for such reconstruction. Para, list after a week. 1 week, yes.
Deputy obliged.
Please, Your Lordship. An affidavit for respondent number 5 has been filed here,
Year for 5.
appearing on behalf of the
Who is 5?
5 is the company, Lordship.
But you are not, you are only a pro forma respondent.
Yes,
Lease is between the petitioner and Mr. Roy, yes. But if the affidavit needs, is it on record?
so it is filed today,
It's not on record.
not on.
Okay, we'll have it on a day convenient to all of you. Tell us, Mr. Ahmed.
28 or 22nd.
After a week, we'll say. Heard Sri Amjad Ahmed, Learned Senior Counsel, assisted by Sri A.M. Datta for the petitioner. Also heard Sri P.K. Roy, Learned Senior Counsel, assisted by Sri S. Chakraborty for the respondent numbers 2, 3, and 4 are going to say, huh? Where, Sri, where is your name?
I am appearing on behalf of Debogod Potter here. That's one.
Your name?
He should hear.
Your
My name is S.J. Sama.
Sri Ajay Sharma, Learned Counsel, has, however, informed on behalf of Sri D. Chutia,
Yes.
Learned Counsel for respondent number 5, that an affidavit in opposition has been filed today, which, however, is not on record. Farah? Let the affidavit be placed on record and the matter be listed for admission hearing after a week.
Copy.
Hmm? Copy has been served upon.
No, my lord. I will
Give a service, copy to Mr. Chakraborty. Yes.
Bishop.
Item 2 and 3.
Please, Lordship, Lordship, in this court of this matter, we have filed our amended post-mortem, Lordship. Lordship may also pray, Lordship, this matter may come up for admission.
It is for admission hearing. Amended cost settlement filed in March to the 2025.
Yes.
What is the difficulty today?
Lordship, in this matter, my senior R. Mozumdar is appearing. He is on back on court number 20, Lord. And Lordship, in item number 2, Lordship, I also need a copy of the affidavit of the other side.
What is the matter? What is the matter?
Lordship, matter this year, Lordship, petitioner, your Lordship, appointed as the Lordship Steno, Sub Inspector Steno, your Lordship. Subsequently, he was your Lordship. Thereafter, subsequently, he has the claim for SCP, your Lordship, assured, your Lordship, assured career progression, Lordship. Subsequently, he was
And
rejected.
Mr. Datta is appearing for whom? Mr. Medhi for whom?
I am from item number 2, your Lordship.
Both are CGC. One
Yes,
is in
yes,
item
sir.
2, one is in item 3.
Yes, sir. I am a transfer bin.
Your
Transfer bin.
transfer.
Transfer bin. It came for transfer bin. But they only request.
You're not here for adjourning matters. Why are you adjourning matters like
Yes,
this?
in fact, the matter has been resolved, your Lordship. The honorable apex court, your Lordship. Your Lordship, what happened, your Lordship? The SCP has been superseded by the MSCP, your Lordship, and give effect to the, your Lordship, 1/9/2008, your Lordship. And his contention is that he has been given the effect from 1/9/2008 instead of 1/1/06, your Lordship.
Okay.
Simple is so.
What do you say?
Lordship, we have paid for benefits from 2006, Lordship, under the modified assured career progression stream. Lordship. That is our concept. And if Lordship permit, I will place the honorable backward suspend your. Next.
A prayer for adjournment has been made on behalf of Sri R. Mazumdar, learned counsel for the same petitioner,
Yes, Lord.
petitioner in these cases, who is the same. Full stop para. Also heard Sri Medhi as well as Sri Datta, learned CGC, appearing in these two cases. Para. In view of the above, list after a week for admission hearing. Yes.
First week of
Hmm?
first week of
All matters. Why first week of June? 2020 matter. After a week.
much of it.
If you reach your
Yes.
Lordship, it is an application for compensated appointment, and the applicant father died on 12/6/2008, but at the time of death, the applicant was minor that time, and subsequently his mother filed an application for the respondent in 2011, but that was not in records. And again, 2016 application.
When was the death? 12/6/8. Death.
12/6/2008.
What was he doing?
Is a constable, grade 4, under the establishment of senior superintendent of police, Guwahati City.
Then at that time you were a minor.
Yes.
Then what happened?
In 2016, my mother filed an application before the respondent, but it was rejected by the respondent, stating that due to late of submission of application.
Mother filed application for on behalf of you.
Yes, yes.
Rejected when?
People,
Two.
02/04/2018.
Okay. Yes.
Again, I have filed an representation dated 21/11/2019, but that was not, petitioner is not getting any response from.
Where is the representation page?
Annexure 5.
Page.
Annexure page 18.
Where is the receipt copy of this
It is not in
representation?
record.
Hmm?
It's not in.
Thereafter? After that?
And then I this petition for
When? 21.
21.
Yes. What are your claims? What is the basis of your claim?
Lordship, at the time of death, I was
Where is the
mine
rejection order?
in case 16. In the serial number 5. And Deputy Patwari.
Yes. Yes, what are your submission?
But at the time of date of my father, I was with minor. Quickly, I
No, is there any law that if you're a minor, it has to be reserved?
no, it is not,
There is no law. Other law is against you.
but I was
And your
incapable apply.
this death is of 2008. We are in 2025. May not have a case. What is your name?
K. Kolit.
Hmm?
K. Kolit.
Calculator. Item number. You are with Mr. B.K. Das.
Yes.
Mr. Dhar would be appearing.
My lord, here, the issue here is that he was a minor. That only will, my lord, not give him any entitlement for this. There is a, my lord, recent judgment of a court following the Supreme Court judgment.
Sanjay Kumar is there, very clear.
Yes, my lord. Then Tapan Saki also, my lord, after placing it. Following the Manipur judgment, my lord, the apex court. Means there is no provision in the OM, our earlier OM, my lord. Now we don't have any OM for this. We have taken out, my lord.
The reason was mentioned that due to late submission of the application. Because
Late submission, my lord. Sadhurunesa will, my lord, cover, my lord, within 1 year. It has to be.
No, by minor, he doesn't, there is no lease. That's lien over the post, not
Yes,
lien
yes,
over the post. That's Sanjay Kumar. Where is Sanjay Kumar? The Bihar case. 2004, I think. Or no, earlier to that. Sanjay Kumar, Bihar.
Because my lord's order, I will take.
No. So Supreme Court
Supreme
order.
Court.
State of Bihar. How can we pass an order of State of Bihar?
My lord, state of Manipur, that Rajodin, that is.
No. See Sanjay Kumar. See the language employed in Sanjay Kumar. Okay, we'll consider. We'll pass orders. Okay. Who are the parties, Mr. Dhar, here? Who are the respondents? For all the respondents. Okay. Yeah.
Item 6.
here in this case, my lord, the second or claim compensation that pension amount. So your lordship would be pleased to see order dated 6/8/2023.
Yes.
The later part of the order, my lord, that has to I already filed a petition before the authority for pension.
Yes.
Now your lordship, I want to bring her on record as a party respondent.
I has to file.
I will file, my lord.
You have not filed.
I have not filed, my lord,
16
because the
2023 was the order.
particulars, my lord, particulars, I could not collect, my lord.
If you
Yesterday
could-
only
if
I
you
am
could
able,
not collect for 2 years.
my lord. I
How can you
able
collect
to,
it now?
able to, there is a problem, my lord. There are two wives. One wife is against other.
Mr. Sheikh, we admit
Information-
that there may be a problem, but how will the problem be resolved if it was not resolved in the last 2
lord.
years?
That is there, my lord.
Problem will be always be there.
Even she is not willing to give the data,
Then how do you resolve?
my lord.
Same thing will remain tomorrow also.
So, my lord, your lordship, give me 1 week time, my lord, I will file.
I can at least give the name, my lord.
Yesterday, my lord, yesterday I have collected the data.
Tubola Prabha. Tubola Rabha.
Tubola Rabha.
Heard Sri M.A. Sheikh learned counsel for the petitioner, as well as Sri R. Dhar, learned additional senior guard advocate. You appear for your DDAS. DDAS on behalf of Sri B. Sharma, standing counsel, AZ. Assam. Madam, you are for Barua. M. Barua. R.M. Barua, learned counsel representing the finance department. Para. As per the last order dated 16/8/2023, comma, the learned counsel for the petitioner was granted time to file an additional affidavit to bring on record the first wife full stop. The matter pertains to a claim for pension. Para. Though the matter was not listed thereafter, comma, Mr. Sheikh, the learned counsel for the petitioner, has informed that he has received instructions very recently and would be filing the affidavit / IA, whatever, IA will be better.
IA will be
IA in this regard, for which he seeks a week's time. Para. Considering that the matter is pending since the year 2021, a week's time is granted for filing the I/affidavit. Para. List after a week.
Obliged.
উপর দিয়ে লিখিছে প্রেস ফর আ উইকস টাইম প্রেস ফর সাম টাইম প্রেস ফর সাম টাইম করে বলে নাম্বার বিশাল আমি উইক করি ইয়েস Item 7. He does. Yes.
Accommodate me for 2-3 minutes, my lord. I just take the file, my lord. Not being able to press the file. A minute or two, my lord. It's a review, my lord.
Yes, you have not been.
I have it, yes. Yes, I.
You have not been
Here-
able to demonstrate.
My lord, here the difficulty is this. I'll just try to, my lord, recapitulate the points on which lordship have
We
given.
know about the position.
But what had happened is these persons had participated in a recruitment proceeding which preceded those office memorandum. The recruitment proceedings at the time when they had applied for the job or when the advertisement came, the OM on which the lordship has given the relief were not in existence. So therefore, any amendment in the OM which was not in existence at the time of the participation of the petitioners.
But it is the same.
It is not. That is what I'm saying. Like, one was relating to the secondary education department, one was relating to the elementary education department. So the advertisement which came for the secondary education department came at a time when the first office memorandum was existing, granting a relaxation in age for people who had acquired qualifications prior to attaining the age of the upper age limit. This was modified by a later amendment saying that no, you need not do it at the time when you were you need not have crossed the age, upper age limit. These persons had participated in another advertisement which was unconnected to that advertisement at a time when these office memorandums were not in existence.
That is the position. The office memorandum came in 2020. They participated in a selection process of 2019.
But where is your ground?
Well, yes, that ground I'll just. Yes. Grounds of review, my lord. 2.2.
Page?
That will be at page 10, my lord.
Yes,
Page 2.2.
para 2.2.
For that, it was brought to notice. It was not brought to notice that the petitioner had sought to apply under the advertisement dated 23/1/2020, where a specific cut-off age limit of 38 years had been prescribed. There was no relaxation at that point of time. The relaxation came in September 2020. So they had participated in a selection process when the office memorandum was not in existence. Yet they got the benefit of age relaxation through lordship's judgment. They did not come before this honor because seeking a relaxation. A later on office memorandum was being tried to be relied upon. So 2.2 and 2.3 is the main contention of the review petitioners. That none of the notifications, that is the notification
heard.
dated 2920.
Sri R. Mazumdar, Learned Standing Council, Education Department. Who has filed this application for review, prothom order to Sulailo, huh? 15/3/2024, huh? The matter was adjourned to enable the Learned Council to obtain instructions on the ground on which the review has been sought for. Full stop. Para. The Learned Council has drawn the attention, has submitted that though by the impugned judgment which was passed in a bunch of writ petitions, comma, so far as the present writ petition is concerned, the same pertained to a recruitment process which was initiated by an advertisement dated 23/1/2020 and 2020, full stop. In the said process, comma, the upper age was stated to be 38 years without any further conditions, and the notifications which were mentioned in the judgment dated 2/9/2020 and 22/2021. Dui, no, 2020 and bis Dui, huh? 2021 were not even in existence and therefore could not have any bearing. Full stop. However, by the impugned judgment, comma, the respondents, the writ petitioners, the respondents of the writ petitioners were are trying to get undue benefit on the strength of the said judgment. Full stop. Para. Let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondents respondents by registered post with AD. Steps within 2 working days. List after 6 weeks. Along with service report. Applicants লিখিব হা দুটো state of Assam and director.
They filed contempt petitions in the matter. One of them has filed a contempt petition.
What to do? Yes.
Obliged.